checked. तुम्हारे ऊपर ही है, जाओगे तो समझ गए।
अभी मेरे सामने
इसको
तो आगे देखो 1 2 1 2 1 2
Sí. check, check, check.
संख्या कर दिया बोल लो वहाँ अभी स्पेलिंग चेंज कर लेना हमारे ग्रुप में है क्या
check, sound check, mic. Mic check. Spell.
सूर्य रेड्डी सर
Sir.
सूर्य रेड्डी सर
Yes, sir.
सर मैं आपको हमेशा अनम्यूट करता हूँ बट सर आपके एंड से ना हमेशा डिस्टरबेंस आती है पीछे सर आपके एंड से इसीलिए बार बार म्यूट करना पड़ता है सर
Sir.
क्योंकि कोड डिस्टर्ब होती है यहाँ पे सर हमेशा डिस्टरबेंस आती है सर तो आपके एंड से डिस्टरबेंस ना हो तो मैं आपको अनम्यूट कर दूंगा सर
Okay, sir.
फाइन थैंक यू check 1 2 3 4 check check check
Mr. Solicitor, just as a matter of assistance, because we'd like you to assist the court as the Solicitor General on this.
Yes.
Can you tell us, after looking at the paper, we'd like your assistance on this. Does this, according to the Government of India, fall within the parameters of the curative jurisdiction? If you could assist us on that, if you feel that it does, how? Otherwise, does the government wish to pursue this matter as falling within the curative jurisdiction? What is the stand of the Government of India? We take it that you have filed a curative petition. So obviously at that stage, there was some application of mine. But what is your, now we'd like the Solicitor General to tell us this.
My lord, that's a little heavy responsibility, but I'll try to discharge, my lord, to the best of my ability. My lord, there are two questions which may perhaps, my lord, fall within curative jurisdiction. My lord, A, the honorable bench was pleased to say that, my lord, our contention was that this
The thing, may perhaps would you like to take a little moment to reflect and come back to us, because these are important matters. It's also a matter of, we have to be fair to each side, obviously to the government, because you have a large financial stake also.
I'll let
At
me.
the same time, there's
Since my lords have put it to me, my lord, I must tell one thing, my lord, to your lordships.
because we are
Came across-
exercising our curative jurisdiction. There are always issues of private investment, the concessioner's interest. We can't ignore both sides. Therefore, we'd like the Solicitor General to look at the papers,
My lord, I will.
sit down
I'll-
dispassionately and tell us what you feel about it.
my lord, then kindly.
Also public interest.
Yeah, of course.
Therefore, I said Solicitor General. We are not saying the Union of India. We'd like you to apply your mind as a Solicitor General and assist us on this.
My lord, kindly have it after 2-3 days, my lord, if it can be done. 2-3, my lord, tomorrow and day after, my lords are in, my lord, the Chief Justice. Huh. Lord, Friday, if possible, my lord, because
Monday, Malas.
It's the last working day of our sister.
no, your lordship,
So
Monday,
in the ceremony, there'll be a little changes and benches and other things. So
Monday, my lord, because tomorrow and day after, my lord, the Chief Justice is in the
the CP. So
Constitution.
So Monday, one. All right.
we'll take it up on that.
Please, giving something else, you can give it to us a day or two in advance. In case is going.
No, we are requesting him to assist us as a Solicitor General, not as a Counsel for Union of India.
My lord, I'm seeking leave to mention a matter, the muscular dystrophy matter. One child has died within 2 weeks. On 9th of August, the matter was to be listed today. 14th August, one more child passed away.
Circulate email, I'll look at it immediately today.
Sorry, my lord?
Circulate an email, I'll have it listed immediately.
My lord,
Item
Very
37, that West Bengal reservation matter, Malad.
Yes.
We need to, the several documents have been filed, we need to file a reply. There is no stay, Malad, so give us some time. We'll file a reply and bring it on record, that's all. Next Monday, if your lordship is.
Monday week or
Next Monday, next Monday.
Well, listen, I am,
West Bengal will take Monday week. Are the others here right now?
Yes, we
Yes,
have
but
informed.
I'm for the commission.
Monday week.
Yes,
No, you're for the commission.
We have informed them.
and I am mentioning with the lordship permission, Malad, that for listing fresh matter, I've sent the email because order 7 rule 11 haven't been dismissed. They are
I
filing.
just sent an email, I'll
I'll
do
send
it.
the email, Malad,
I'll take it out this
I'm
afternoon.
requesting for Friday if possible.
I'll
Very good.
issue it. Direct.
my lord, I
See,
seek to
one
mention.
indulgence.
Vanshika, all listings and emails I'll attend to today in the
Obliged,
afternoon.
obliged.
Just if you have not sent your emails, send them. I'll have the whole sheaf of emails in the afternoon. I'll give listing dates.
My lord,
We have
my lord,
already sent an email.
If
I've already sent it.
something is being demolished, if some demolition is taking place, mention it right now.
my lord,
All of the matters, please rest assured there'll be dates if possible to speak for fresh matters, depending on the boards, how heavy they are.
I
My
can
lords,
press my lords. The only issue is that my lords had fixed the date on 14th of August, that matter. It didn't come up, my lords. I sent a letter.
All right, I'll make sure.
my lords, only
This is the senior most serving officer. My lords had asked to file the army to file the reply. My lords, the
Femi
matter
was
was
not here
listed
last
on
time.
23rd of August. She is retiring on 31st August, my lords.
Okay,
23rd.
just say that in your email. We'll just
Yes,
say
my
that.
lords, I've already sent the email.
my lords, this is with,
Yes.
Friday.
My
because
lords.
Otherwise, she'll retire.
Can't give, if I start doing it for one council, I have to do it for everybody.
my lords,
Send it in your email. Please rest assured your emails will.
my lords, this is with reference to the
Lordship, if your lordship
PWD
permits me, I
candidates.
mention an after notice matter. Lordship, this is an extra.
What's the
Lordship, there is a urgency. Lordship, your lordships have already fixed a date, 2nd of September. However, lordship, the subject matter is racing. That will already be completed by 2nd because now the racing event has already been preponed. Lordship, my only
Racing
request is
what?
that. Lordship, there is a racing event that is happening in state of Tamil Nadu where they are obstructing the entire road. There are hospitals. There is the Honorable High Court. The passage
Do
is.
you want to put an end to the race which is going to be held?
They may take another track. That is the subject matter of the SLP before your lordship.
We'll deal with it. I mean,
My
if
lords.
if these matters we give urgency, you know what it is. Yes.
My lords, this is with reference to the PW.
Medical college students are being transferred out. There's an urgency. We'll be sending.
So why don't you all just send an email? Just say that in one sentence in an email. I'll immediately put my noting and give a date to him because then he knows what to list. Just do it in the afternoon. I said I spent probably 45 minutes to an hour in the evenings on listing emails.
With the lordship's permission, my lords, may mention a matter which was heard last.
I have to say the same thing over and
This is not with regard to any listing or anything, my lords. This order was passed by lordship on 14th of August, asking, my lords, in the arbitration matter, the lordship said that the foreign parties file an affidavit within a week before Friday. My lords, we had, because it's a disposed of matter, my lords, the computer would not accept the affidavits even though we got it by scan. Plus, we've now got the original, so the only request is that at least that be taken on record.
Please file your scanned affidavit. Or it will be taken on the record. It's taken on the record.
My lords, the Rajasthan Judicial Services PWD exam.
My lords, it was listed on 9. My lords had given a date for 27th August because the NCLT was hearing it today. It's not listed today. I sent an email on Friday and today also. My lords, we'll have it next week.
My lord, a similar situation, the PWD candidates in the Rajasthan Judicial Services, the exam is to be held on the 31st of August.
Just Bela Trivedi has delivered judgment.
My lords,
That there doesn't have to be a separate cutoff.
my lords, the judgment of Justice Bela Trivedi has far-reaching implications. My lords, my lords, on last
Therefore,
occasion.
that judgment is prima facie against you. So we list the matter, but we can't now, there's directly a judgment against you on the point. And we had adjourned this matter only to await the judgment of a coordinator.
Please, my lords, however, there are certain things to
However,
be
there's
pointed out.
nothing to list the matter. We'll list the matter. But
My
now
lords, the exam is on the 31st.
also understand that there's a direct judgment against you. We adjourn the matter to await that judgment. There's a direct judgment against you. We'll hear the matter, of course, because we are in a combination of three. That judgment doesn't bind us. But of course, it's entitled to great weight because it's a coordinate bench. So we list the matter.
My lords, mention a matter. My lords, this is regarding.
The attorney wants to.
There's a civil appeal for some directions is related to Supertech. This court had come and taken cognizance of whether project resolution process can be undertaken. The NCLT is in the process of receiving an application by NBCC on the lines of Amrapali. And once the direction is given here, NCLT can take up this matter next week. Sometime on 6th, the matter is being listed. Any date for direction, the matter can be given.
We list for direction.
Very good.
Lord, one request which is for the matter listed today. Item 53, that BCCI matter, my lord. Others are here, my lord. There is some, 2 more applications have come. So the request is, my lord, sooner the matter is decided one way or the other.
Yeah.
Better, my lord.
I'm endorsing that.
Yes, we also support it. Any day.
With my lord's permission, may I mention a matter, my lords? My lords, the constitution bench matter which is coming up tomorrow, my lord, there's a connected, similar issue pending before SLP civil number 646 pending before Justice Bela Trivedi.
Nothing will be brought here. We'll hear whatever is on our board tomorrow.
Please, my
If you want to intervene in this, you can intervene.
Obliged, my lords.
My lords, may I mention a matter? My lords, this is regarding omission of appearance in the RG Corn matter. We were appearing for one of the interveners and our appearance has not been entered in the order.
Yes, you can give your appearance.
My lords.
I have circulated 2 notes for your lordship's kind
Request to make
consideration.
this
my lords.
matter.
I have circulated 2 notes for your lordship's kind consideration.
Now, which are the states which have complied? We'll first get them out of the picture because there were many
The
states
state
which had
of
complied.
West Bengal has
Pradesh has filed an
filed.
affidavit.
The chief secretary is also present.
Madhya Pradesh has filed an affidavit showing
I
that
have
they have fully complied and copies given to the amicus.
Yes.
They are complied with it. So far as Meghalaya, Himachal, Madhya Pradesh and TN are concerned, Tamil Nadu are concerned, my lord, those are clear to me.
Madhya Pradesh?
Madhya Pradesh, they have complied. Madhya Pradesh, Himachal, Meghalaya and Tamil Nadu.
Madhya Pradesh, Tamil Nadu,
West Bengal also I gave it to order.
Meghalaya and Himachal.
Meghalaya, Himachal, Madhya Pradesh, Tamil Nadu, my lords. So far as Tamil Nadu is concerned, just one order is required that they have made available those funds. The judicial officer to raise the bills within 4 weeks and thereafter within 4 weeks the state should comply with it. Otherwise, these 4 states are clear. Your lordships may.
All right.
So West Bengal is also.
First of the order dated 22 August 2024, the chief secretaries and finance secretaries of the states of bracket 1 Tamil Nadu, 2 Madhya Pradesh, 3 Meghalaya and 4 Himachal Pradesh. Mr. K. Parmeshwar, the amicus curiae, states that the above 4 states need not be, that proceedings against the aforesaid states, the above 4 states need not be pursued any further. Stop. Insofar next. Don't say next. Insofar as the state of Tamil Nadu is concerned, it will be stated that the funds have been made available for disbursement to the judicial officers. Stop. The judicial officers are accordingly, next line, the judicial officers in the state of Tamil Nadu are accordingly permitted to raise their bills as requested by the, in terms of the request made to this court on behalf of the state of Tamil Nadu within a period of 4 weeks. Stop. It has been agreed that it has been stated. Who's appearing for the state of Tamil Nadu?
I am appearing for this.
It has been stated on behalf of the state of Tamil Nadu by that disbursement will be made to the judicial officers within a period of 4 weeks from the date of the raising of the bills. Stop. So for the states of Madhya Pradesh, Meghalaya and Himachal Pradesh are concerned, compliance has been effected.
Your lordship, if I may make a mention with regard to the state of Chhattisgarh, your lord.
Are you any of these 4 states?
Yes.
Are you?
Chief Secretary.
Are you any of these 4 states? Bide your time. Yes.
Lord, we are compliant. Lord.
That's what it is.
Right, so we have closed now so far as these 4 states are concerned.
Let's run through this list.
Sorry?
As the others are concerned, we'll just quickly run through this list because I have circulated the note to everyone.
Bill for the state of Tamil Nadu, they have to raise a bill on whom?
The bills are to be made, claims are to be made to the registrar through High Court, because these are allowances where the calculation has to be made by the officer, like how many children education allowance, etc. So that bills have to be submitted
The drawing and disbursing officer has to.
and then disbursing of
The claims have to be. I'll correct that.
But state of West Bengal is also released all funds and now only bills have to be raised.
I'm sorry, the last part I didn't get.
The state of, the bills identically, my lord, the drawing and disbursing officers have to raise the bills and all amount will be paid, which is balance.
Just see, just.
Similar is the position
One
in Arya also.
One second, we take up West Bengal.
West Bengal. So far as state of West Bengal is concerned, Manoj, the affidavit was silent as to how much was actually disbursed. Today morning, they have now filed a statement. They have just shown me.
I've given an order, my lord.
All the monies have been disbursed. So your lordship will record that the state will make available all resources as soon as the bills are raised. Those will also be.
That order itself states.
Yes, shows the order.
Yes. I have a copy of this.
Milord,
In fact, I gave you the copy in the morning. In fact, the order says even if there is shortcoming, you pay it, it will be then later on adjusted.
If your lordship's permit, Milord. Yes.
What this order says, 26th August order says is this memorandum says is that the finance ministry has allocated the funds to the law ministry. So the lordship sees from the above, it is evident that a necessary amount of fund has been released by the finance department for payment of arrear allowances on the basis of claim has been received. The judicial department has requested to reassess the exact requirement of fund for payment. Arrear with a detailed breakup, if any, and furnish the same to the finance department immediately. Is what they say.
Now let's look at the next paragraph. It is however further directed that required fund is not available under concerned head to the treasury as the case may be will arrange for disbursement in anticipation of allotment. So even if there is some discrepancy, they will release the funds.
We take this on the record.
There's just one, if your lordship just see page 6 of my note, Malad. Just page 6 of my note. So far as West Bengal is concerned, one more item was pending. Para 22, page 6 of my note. By affidavit dated 19/8/20 for the state of West Bengal, it is stated that allowances have been revised except for higher education qualification allowance, which is pending hearing in IA number 103071 of 23 months. This this IA months we couldn't look at, it's not there in the case status also. And in any way, there's no question of non-compliance so far as one allowance is concerned. So that also your lordship will actually clarify that para 41 of your lordship judgment of 4/1/24, 4th January 24 will have to be complied. 41.
Medical
43, 41 to 43 minutes. So far as higher education allowance is concerned. This IA we were not able to track at all.
That will be released also.
We have heard Mr. State of West Bengal, not in every state separately. ऊपर वो state का नाम क्या रखना State of West Bengal, Mr. Rakesh Dwivedi, then senior counsel appearing on behalf of the state of West Bengal, tendered copy of the memorandum dated 26 August 2024, issued by the Finance Audit Department in the following terms. Copy kar lijiye, and just scan it and copy it. In view of the above memorandum, and the compliance which has been effected by the state of West Bengal, no further proceedings unless
The bills, DDO will have to raise the bills, drawing and disbursing officer.
drawing and disbursing officer shall raise the bills within a period of
And they will, yes, and they will disburse immediately.
4 weeks. And the disbursement shall be made within a period of 4 weeks of the bills being raised. Next.
But the chief secretary and the officers are here, they may be exempted.
Yes.
And
With your lordship's kindly.
we apologize for the delay.
So, the problem is there are so many states have complied. The problem is when matters are called out repeatedly, the council are absent here. We don't know what to do then, that's the reason why we had to.
Chief secretary here will note your lot.
We also have no great pleasure in calling the chief secretaries and finance secretaries here.
I
But
understand this.
consistently we call out matters, now they have briefed Mr. Dwivedi when.
Lord, even the state.
Your lordship that.
All right, just 1 second. Mr. Rakesh Dwivedi has also assured the court that the payment of the higher education, the higher qualification allowance will also be duly effective in view of the directions contained, shall be effective, full stop. The directions issued by this court in its order dated 4/1/2024, in brackets paragraphs 41 to 43, are expressly clear, and hence above payments against the above allowance shall also be duly disbursed within the same.
The presence of the officers may be exempt.
My lord, as far as the state of
Proceedings against the state of West Bengal, so far as this aspect need not be pursued any further.
My lord,
Just follow the matter.
Just 1 second.
my lord, in
Your Lordship,
respect of
Now what we'll do is,
Odisha,
page,
3 Odisha.
all right, who's appearing for Odisha?
my lord, I am appearing for the state. In
That's the
respect
reason
of
why
those
they were not
first four
compliant.
states,
1 second, now let's see.
respect of Tamil Nadu, RB, presence of the officer is dispensed.
Dispense with, we close the proceedings.
With regard to Tamil Nadu, my lord, there is one difficulty, my lord. The transportation charges are given only with the cars owned in the legal officers. There is some difficulty. The commission says the car owned in the name of the judge as well as of the spouse. But the order says only in the name of the judges. There is some difficulty with regard to that.
Because so far as these individual grievances, there are about 100 grievances that have come up. In the last 2 weeks, I have received emails from different associations of judicial officers. The purpose of constituting a committee by your lordship's order dated 4/1/24 was for exactly this purpose.
So that we are now not required to look at the nitty-gritty of each individual.
That's right, my lords. So that if there are minor problems, it is sorted at that level, my lords. That's number one. Number two, I should also point out to your lordships, my lord, unfortunately, in certain high courts, the committees have not sat for the last 3-4 months. So at the end of today's orders, your lordships.
Just remind us so that we pass this order to
that must sit
the committees in the High Court should sit at least once every fortnight.
That's
what were you going to suggest?
Once a month.
Once a month,
Once a month, because it is because it is the But then the problems will just take care. Otherwise, these.
Right. Just remind us before we rise. The matter is over today. Now, Odisha.
Odisha is concerned. If your lordship just kindly sees page 8, my lords. What they had done was they had implemented your lordship's order. Page 3, para 8, my lords.
Yes.
They had filed an affidavit stating that all the areas, etc., have been sanctioned. But if you just, the highlighted portion which is underlined, my lords, judicial officers from the state of Odisha also brought to the notice of the amicus that an office memorandum dated 29/2/2024 had been issued, mandating that actual disbursement of arrears shall be made over a period of 3 succeeding years. This was further clarified in May, my lords. A subsequent office memorandum dated 16/5/24 mandated that drawal of funds for arrears of allowances in 3 phases from 2024 to 2027. So this is why I had categorized them as a defaulting state, my lords, because your lordships had directed that all arrears should have been cleared by at least July 2024. So this now stands withdrawn according to an affidavit they have now filed on Saturday. That your lordships will get at page 4, para 10. So far as Odisha is concerned, since this was the concern that all arrears were to be distributed over a period of 3 financial years, my lords.
That is withdrawn. So we can close it now.
Lords, just record this and then close it so that.
Yes. State of Odisha. An office memorandum was issued on 29 February 2024, mandating that the actual disbursement of arrears would be made over a period of 3 succeeding financial years, commencing from 1 April 2024. Put stop by a subsequent OM dated 16 May 2024. It was mandated that the drawal of funds for arrears of allowance in 3 phases it was mandated that the drawal of funds for arrears of allowance would be allowed in 3 phases from 2024 to 2027, into brackets 33%, 33%, and 34% respectively. However, an additional affidavit has been filed on behalf of the state of Odisha on 23 August 2024, indicating that the previous OMs dated 29 February 2024 and 16 May 2024, which mandated only partial withdrawal of arrears in phases over 3 years, now stands withdrawn. To stop, the additional affidavit has indicated that 44 bills remain pending for processing in respect of arrears of pay, pension, and allowance. Of this process shall be completed. The above bills shall be processed and payments shall be made no later than within 4 weeks from the date.
May I just state that these 44 bills have come only after the first affidavit was filed.
there's an instruction by the state government to the treasury to make the payment because all the amount is with the treasury, the entire amount. So there's an instruction to pay within 3 days.
All right.
So that's
Then last sentence you strike out, can say, then it's senior counsel, then counsel appearing on behalf of the state of Odisha states that instructions have been already issued to the treasury of the state government to ensure that payment is made within a period of 3 days. The assurance is recorded. In this view of the matter, the proceedings against the state of Odisha on this aspect should stand closed.
the chief secretary and the finance secretary are here in the court.
Do this on time and tell us when the matter is called out that this is done. Yes.
Very great.
Tamil Nadu is done, my lords. Page 4, Tamil Nadu is done. Page 5, Bihar was concerned, my lords. Your lordships had recorded the oral submission made by the council on 11/7, para 18. The council appearing to the state of Bihar, I'm just quoting from the relevant portion of the order dated 11/7. The council appearing to the state of Bihar states that an amount of rupees 122 crores has been transferred to the Law and Justice Department and the payments are being made in full compliance of the orders of this court. Let's what we did, we circulated a questionnaire to all states so that they can upload the relevant documents and also answer on the questionnaire. Bihar did not respond to that. No affidavit also filed. Now they have filed pursuant to your lordship's last week's order summoning the chief secretaries. They have now filed an affidavit stating that they are in full compliance. The reason why Bihar was earlier classified as a non-compliant state was they neither responded to the questionnaire. We circulated an online questionnaire so that specific answers could be obtained.
Who's appearing for this?
My lord, I am appearing for the state of Bihar. My lord, the compliance has been made. It's only because the affidavit was not filed.
State of Bihar, Bihar on 11 July 2024, the following statement of the council for the state was recorded. To invert from us, ये परमेश्वर जी के नोट में para 18 में copy कर लीजिए quoted portion. Pursuant to the above order, a questionnaire was circulated by the amicus curiae seeking an update on all aspects. Since the state of Bihar did not either file a response to the questionnaire, nor did it file any affidavit until 24 August 2024, it was classified as a defaulting state. However, on 24 August 2024, the state has filed an affidavit indicating that it has fully complied with the orders of this court with respect to division of pay, pension, and allowances. But the allowances were revised by a resolution dated 28 February 2024. It has been stated that all the claims made in respect of the arrears of allowances have been disposed of. In view of the above compliance, the proceedings against the state of Bihar, insofar as the above aspect is concerned, shall stand closed.
Personal appearance may be discussed.
Personal appearance is personal appearance is discussed.
Page 6.
Now we've got
page 6.
I'll just keep on ticking now. Now we are dealing with Kerala.
So far as Kerala also is concerned, the same Odisha technique was employed, saying that we have cleared all bills, but there will be a lock-in period. Well, will kindly see para 24. In respect of payment of arrears of allowances as per geo dated so-and-so of 4th March 2024, arrears of allowances were to be credited subject to the condition that the amount could be withdrawn only after a lock-in period of 2 financial years. Further, arrears were to be disbursed in 3 installments of 6 months each over a period of 2 financial years. Now on 20th, my lords, they have now withdrawn this after we pointed it out to them that this lock-in period was not orders. They have now withdrawn this lock-in period. But what has happened, my lords, is that pursuant to the March 24 order, they transferred all these amounts wherever they were cleared to a number of judicial officers to their PF account. And that PF was to be touched only at the time of retirement. So that transfer has already happened so far as compliance with the 4th March 24 orders was happened. So your lordship will have to direct that wherever those transfers have happened to the PF account, we'll have to go back to the salary account. So after all arrears, how can arrears be deferred, my lords, and that too for allowances? So medical allowance, DA, etc. They credited it, but they said we'll credit it to the PF account so that you can't utilize it until you retire. The entire purpose of giving allowances and arrears is defeated.
Lord,
permission. I'm appearing for the serving officers, your lordship. Lot of other animals also there, your lordship. I will file a response for that. I'm appearing.
I'm appearing for the state, my lord. We accept the position, my lord. We are in the process, my lord, of transferring it from the PF account to, my lord, the salary account.
Lordship, not only that, Lordship, lot of other problems also there. Let me, I am appealing for the serving officers.
We are arguing before the Supreme Court. We are not going to deal with individual grievances like this. Therefore, we have institutionalized the process. We have constituted committees in the High Courts specifically to deal with this. We are dealing now with national issues where there was an overall non-compliance. Individual issues placing before the committee, we are going to pass an order. Rest assured, we will not leave you in the lurch.
Please.
You are our judicial officers. So we will not leave you in the lurch. We'll pass a general direction for these kind of grievances. Don't worry about it.
Please, Your Lordship, only consider the grievance what we are pointing out. That's only, Your Lordship.
Will be more interested in.
Don't worry, we'll deal with it.
But so far as the.
Your Lordship may pass the usual order as far as the persons are concerned. But they are here. The Chief Secretary.
Yes, yes.
There's the same order.
Kerala. By geo. Just 1 second, ma'am. By geo number 66/2024, home dated 4 March 2024. Kerala had directed that arrears of allowance would be credited subject to the condition that the amount would be withdrawn only after the lock-in period of 2 financial years. Moreover, the arrears were to be disbursed in 3 installments of 6 months each, spread over a period of 2 financial years. However, a subsequent GO dated 20 August 2024 has rectified the anomalies which were pointed out by the Registrar General of the High Court in respect of the various allowances. The GO withdraws the lock-in condition and the condition for disbursal of arrears in 3 installments. Mr. K. Parmeshwar, the amicus curiae, further has pointed out that where the amounts were credited, the credit was made to the PF accounts of the individual officers, which would effectively mean that the availment of the arrears would stand deferred until the date of retirement. Mr. Jaideep Gupta, Learned Senior Counsel, appearing on behalf of the state of Kerala, has stated in response to the above submission that the state of Kerala has already taken steps to reverse the position so that the amounts which were credited to the PF accounts would be retransferred to the salary accounts of the judicial officers. The GO also states that the GO dated 20 August 2024 states that disbursement of arrears would be made as and when bills are presented. Following the the bills shall be presented within a period of 4 weeks. The disbursement shall be made on or before within a period of 4 weeks from the date of the presentation of the respective bills.
Yes.
The proceedings in respect of the state of Kerala shall accordingly stand closed and personal presence is dispensed with. So we are done with now Kerala, which is the next state?
UT of Jammu and Kashmir. So far they are concerned, there is no revision that has happened of allowances, not just payment. Revision of allowances has not happened. Therefore, consequently, payment of arrears also has not happened. So their response
serious problem.
So they say that the union government has to sanction the revision and the arrears are concerned. The union government had filed a revision review petition before your lordship, which your lordships have now dismissed on 31st July 2024, so far as all union territories are concerned. So there's no question of now relooking.
We just hold back Jammu and Kashmir and Ladakh for a moment. Now, what about Delhi? What about Delhi?
Yes, goes for UT of J&K and Delhi. That was the problem. Now, since the review is dismissed, I will go ahead with this.
So far as Jammu, Kashmir, Ladakh, Delhi, all of it await union permissions. So all of them await union permissions.
Union concurrence was required. Now, since review is dismissed, we have
the Jammu and Kashmir, Ladakh, and Delhi. Mr. K. M. Natraj, the petition seeking petition seeking review of the judgment of this court dated
4/1/24
for January 2024 into brackets review petition number
2970 diary 29704 of 2024
has been dismissed by an order dated
31st July.
31 July 2024. Next, Mr. K. M. Natraj, Additional Solicitor General states that in view of the dismissal of the review petitions, necessary permissions will be issued by the Union of India within,
At the earliest, about 6 weeks.
at the earliest, 4 weeks. Full stop. All disbursements shall be made to the judicial officers within a period of 4 weeks
Thereafter. Great.
The proceedings against the above states, above duties are accordingly closed.
Great.
So Delhi is, just 1 second, let me take, Delhi is done. Then we have done Jammu and Kashmir. Jharkhand.
So far as Jharkhand is concerned, my lord, the affidavit, if your lordships kindly see para 35 and 36, my lords, they are 90% compliant on pay, pension, etc. my lords. On so far as arrears is concerned, my lords, the affidavit was silent on what was transferred to the relevant district headquarters and how much was actually disbursed. So following the West Bengal order, your lordships have now dictated, and the Kerala order, your lordships have now dictated. Your lordships can say that whatever remaining amount is there so far as Jharkhand is concerned on payment of allowances, my lords, bills will be raised within a period of 4 weeks and they will clear it within a period of 4 weeks.
The district judge himself is the one person.
DDO. In a lot of states, this is a problem because the funds are being made available to the law department, my lords, because since the principal district judge is also the DDO, district disbursement officer, my lords, raising of bills has occasioned, because of the delay in raising of bills of allowances, funds could not be transferred. So for Jharkhand also, your lordship will could pass the same order as West Bengal and Kerala, saying that they will make available the funds. And that
on behalf of the state of Jharkhand, an affidavit has been filed on 17 August 2024. Stop. The state of Jharkhand has stated that payment of arrears of pay has been cleared for all judicial officers, and the majority of the officers has been paid the arrears of pension. Except for 7 allowances, the rest of the allowances have been approved on 19 July, 8 August, and 13 August 2024. Good stop. Learned counsel appearing on behalf of the state, Learned senior counsel appearing on behalf of the state of Jharkhand states that the district judge is the drawing and disbursing officer in the state of Jharkhand. Good stop. Next, to facilitate payment to the judicial officers, it is directed that the drawing and disbursing officer shall raise their bills within a period of 4 weeks from the date of this order. Good stop.
The concerned judicial officer has to make a claim, and then the judicial officer.
Okay, we'll say that the concerned judicial officers shall make their claims, place their claims before the drawing and disbursing officers within a period of 4 weeks from the date of this order. Good stop. The payment shall be made within a period of 4 weeks. Within a period of 4 weeks of the lodging of the respective claims. So, proceedings closed. So now we conclude Jharkhand. Then what about
Andhra Pradesh? Andhra Pradesh, in its affidavit dated 20th August 24, it had sought for
only the usual order for dispensing.
Yes, that we dictated earlier, so we are doing that.
Para 39, my lords. Para 39. However, in the affidavit dated 20th August 24, a period of 4 weeks is sought for clearing of pending bills. So the same orders may be passed, same like that.
My lords, the same issues with the DDOs arise. Therefore, the same order as was passed in the case of Jharkhand.
There was some technical hitch, my lord, of uploading bills.
That has been addressed. That has been addressed and payments have been made subsequently.
Para 39, in its affidavit dated 20 August 2024, the state of Andhra Pradesh has sought a period of 4 weeks for clearing all pending bills. And then the same order as in the case of Jharkhand, drawing and disbursing officer. Is the district judge the drawing and disbursing officer?
The case may be whether, depending on the grade of the judicial officer, whether they are in High Court or a district.
Don't say the district judge is a
DDO, my lords, could be in the High Court or the district court.
All right. The DDO to the claim shall be made within a period of 4 weeks to that drawing and disbursing officer, and thereafter within a period of 4 weeks.
4 weeks payment.
So Andhra is done.
Madhya Pradesh,
Andhra Pradesh High Court.
compliant.
May I say this,
One second, Madhya Pradesh has complied. We had already passed a general order for Madhya Pradesh.
Chhattisgarh, my lords, only 4 allowances were remaining. My lords, para 46, if your lordship just reads the highlighted portion, underlined portion.
All right, now who is appearing?
Your Lordship, I am appearing for Chhattisgarh. Your Lordship, the state has sufficiently allocated all the budget to the district, to the High Courts, and High Court has equally disbursed all the money. We have also put in the proof of payment, which is marked as an annexure in the new affidavit, which has been filed on 24th. And as per the instruction I have received, as on date, there are no bills pending with the Treasury, Your Lordships.
In the 24th August affidavit, my lords, for lordship, may I just place para 46. By the affidavit dated 24th August 24, it is stated that information was received by the state from the High Court regarding disbursement of allowances. The High Court has stated that sufficient budget has been allocated by the state and the payments are being processed by the High Court as per submission of bills. A chart prepared on the basis of the information received from the High Court is annexed at page 702 of volume GG. The chart indicates that arrears in respect of 4 allowances are in the process of being paid: concurrent charge allowance, higher qualification allowance, telephone facility not being paid, and hilltop area allowance. These are not being paid, my lords. The Judges Association also say.
Your Lordship, with regard to those 4 allowances, whatever bill has been put on, so till date has been cleared. So as and when the bill will be put up, the same will be cleared.
Your Lordship, just grant them 4 weeks and ask them to clark these 4.
Appearance note, in its affidavit dated 24 August 2024, the state of Chhattisgarh has stated that information was received by the state from the High Court regarding the disbursement of allowances. Let's stop. The High Court has stated that a sufficient budget has been allocated by the state and payments are being processed by the High Court as against the submission of bills. First stop. The amicus curiae, however, states that it appears that arrears in respect of 4 allowances are still in the process of being paid. The bracket charge allowance, higher qualification allowance, telephone facility, area allowance, bracket. Learned Counsel appearing on behalf of the state of Chhattisgarh states that that payments would be made as soon as bills are received. A full stop. We direct that the exercise be completed within 4 weeks.
Your Lordship, the payments has been made. Any further bill which will be put up, the payments will be made.
Learned Counsel of the state of Jharkhand stated that while payments have already been made, any further payments which remain due would be made within a period of 4 weeks for the receipt of bills. The statement on behalf of the state of Jharkhand is accepted. Chhattisgarh is accepted. Compliance be effected in the above terms. The Registrar General of the High Court shall monitor compliance, and in the event that there is any further difficulty, bring it to the notice of the committee of judges constituted by this court by its order dated 4 January 2020.
Your Lordship, personal presence of.
Yes, we are closing it. Yes.
Exempted.
Yes.
Please oblige.
My lords, I'm very sorry to interrupt. My lords, in case of Andhra, the presence of the Chief Secretary and Finance Secretary may be recorded.
Yes, we already closed it.
It may be recorded.
Yes.
Obliged.
That's a standard order for all states where we are recording compliance.
This Assam has not paid a single paisa for his allowances.
Lordship, the notification, Lordship, has been issued on 12th of August, and then Lordship on 16th of August. It's also noted in the note of learned amicus. On 16th of August, Lordship, the entire budget has been made available. Nothing. It's Lordship now. For the DDOs, Lordship, there are 204 DDOs who are basically, Lordship, in the High Court and in the subdivisional courts, Lordship. Whenever, Lordship, the bills will be raised, Lordship, within 4 weeks, Lordship, we can make the payment will be made. The funds are available, Lordship.
To contradict.
This is not good enough.
The funds are available. Is we will keep it after. We will keep it. You first tell us when are you going to
color of money.
When is the money going to be disbursed?
Lordship, the money is made available, Lordship. It is now the process that happens is that the DDOs, Lordship, will raise the bills, Lordship. As and when they raise the bill, within 4 weeks, we will disburse the money, Lordship. The money is available. Even in the note of the amicus, Lordship, it is needed. They say.
Where is, you said that the budget is being made available. Where is the money lying right now?
It's not done.
Have you transferred it to the treasury?
Lordship, the money will be.
Have you transferred it to the treasury or not for the purpose of disbursement? No. Where is the secretary? Where are they? Ask them.
Has the money been transferred to the treasury, sir?
Then make a statement accordingly.
When?
Then that's all right. Then we'll,
When?
State of Assam, parents note, Learned Counsel appearing on behalf of the State of Assam and the Chief Secretary.
And the Finance Secretary, both of them are present, Lordship.
States that on 12 August 2024, a notification has been issued by the state government and necessary budgetary allocations have been made on 10 August 2024. However, it has been stated that there are 204 drawing and disbursing officers, the state, and as soon as the bills are received, payment would be made
within 4 weeks.
Within 4 weeks.
Well,
You can say the same thing.
I am representing the Assam Judicial Service Officers Association. Although the notification has been issued on 12th of August, well, so far as the risk allowance is concerned, they have confined it only 10%, as against entitled 30%. That may be, the recorded, because we are entitled to 30%.
Direction for
The
30%.
other criminal employees are given
no direction for
30%.
30%.
Anyway, if they have a grievance, they can move the High Court.
Yes, Lordship, let them.
This is an overall thing we'll close here. Yes.
That may be recorded in the order, that in case of any grievance relating to the percentage, we may move the High Court.
Of course you can. By a previous order, therefore we have constituted that committee.
My lordship,
Yes.
at the end of
Lordship,
this order, just reiterate that portion because we are
Any other remaining point?
flooded with,
Just remind us before we close.
we are being flooded with these individual, my lord, allowances where there are tweaking. So your lordship may clarify it at the end.
Lordship may dispense with the appearance of the.
Yes, of course.
Obliged.
Keep this.
As far as Nagaland is concerned, page 12, they said the affidavits, the latest affidavit of 16th August said that they have actually cleared. But there is a paragraph there which I have extracted at para 51 of my note. It is however clarified that this amount does not include pension, family pension and pension areas to the retired judicial officers. If your lordship just clarify.
Your lordship, the amicus has circulated a questionnaire where we have given proof where it has been given. Now, in the state of Nagaland, insofar as the pensioners are concerned, it goes to the treasury directly from the accountant general, which is why we are not being able to give the exact amount, how much has been disbursed. That is the only clarification that we have given. Otherwise, the proof has been given that the pension as well as the areas have been paid.
Pay areas, allowance areas, all that has been cleared. Only pension, I think, because of this problem, because it's directly being transferred, they were not being.
I am representing the Nagaland Judges Association. Well, 3 allowances are not being given. Number 1, risk allowance is not being given.
Which one?
Medical risk allowance is not being given. They want clarification on that.
Para 53.
Your lordship, we have filed an application insofar as the
Seeking
risk
clarification.
allowance is concerned.
All other states, northeastern states have been given the risk allowance. Why not the Nagaland?
Your lordship, we have filed an application. Our application is at page PDF 238 of the volume GG that the amicus has circulated.
There are 2 applications that Nagaland is filing. One, your lordships in your lordship's order of 4th January 24 said that risk allowance is given for posting if the same allowance is being given to other civil servants. So the state of Nagaland now says that its civil servants, although it's an insurgent affected area in some parts, its officers are not getting, civil servants are not getting it. So therefore, judicial officers are also not entitled to get it. The lordship's order was very clear. That
Very clear.
Officers will be entitled at a rate applicable to civil servants. So if civil servants are not getting it, and that's the standard of the state of Nagaland, then therefore judicial.
We have annexed the opinion of the AG also.
Then if they are not, if civil servants are not getting it, then the
Yes, your lordship, that is why the clarification has been filed.
allowance is concerned.
No, my lord, your lordship will kindly make an inquiry. The civil servants are getting the allowances. So far as the All India services are concerned, they are getting it at the rate of 30%.
Your lordship, I have annexed the opinion.
That will be a misleading fact, my lord.
This issue may be left to the committee and then your lordships will have a view on this. Otherwise, this application, clarification, there are 7, my lord.
All right, let it be.
There are 2 other allowances, there's a problem with it. Now, if your lordships are to go into all 3 allowances here, then this entire business of the committee will, my lord, this IA for clarification, the committee will look at and decide about these 3 allowances.
Your lordship, may I be permitted to submit?
Find some solution. The state of Nagaland, in its affidavit dated 16 August 2024, the state of Nagaland has stated that arrears of pension have been cleared, semicolon, full stop. Moreover, amounts of rupees 4 crores and rupees 9.32 lakhs have been released on 15 July 2024 and 25 July 2024 for the payment of the arrears of allowances. Full stop. So far, comma, the state has made payment up to rupees 10 lakhs, right?
10 crores, Your Lordship.
Is it 10 crores in your para?
I think my zeros, I would have losses.
Your Lordship, it cannot be 10 lakhs.
The state has made payments of
05
of rupees 10 crores.
Yes, Your Lordship.
However, the state has indicated that however, the further statement is in the following terms. Colon, ये इनके नोट में para 51 में ले लीजिए.
Order dated 4/1/24. That's 10 crores, my lords.
10 crores. Yes.
My mistake.
No risk allowance. Learned Council appearing on behalf of the state of Nagaland states that no risk allowance has been sanctioned for the reason that the civil servants are not receiving it.
Yes, Your Lord. In fact, this issue was brought up with
Well,
the
that is
committee.
not correct, my lord. May I clarify that position is not correct.
The moment you start speaking, he will start retorting. So we'll find an answer.
Your Lordship, the committee had.
Discretion lies in just keeping quiet. We are protecting you. Just 1 second.
Okay.
The statement made on behalf of the state of Nagaland is, however, disputed on behalf of the judicial officers. Is disputed by Mr. B.K. Sharma, Learned Senior Counsel, appearing on behalf of the judicial officers of the state of Nagaland. In order to obviate any difficulty, we leave it open to we direct that the committee of judges constituted in pursuance of the judgment of this court dated 4 January 2024 shall verify whether the payment of risk allowance is being made to civil servants. Full stop. The order of this court clarifies that payment of risk allowance shall be made at the same rate as is paid as is made to civil servants.
Civil servants.
Para 68 and 69.
My lord,
Your Lordship, may I pray that
Well,
it may be
may be
clarified.
permitted
In
to
case
point
there is
out
no
two more
payment,
things.
then the state will not be required.
Whether any risk allowance is paid to the civil service officers in the state of Nagaland is a matter which should be verified by the committee. Full stop. In the event, it is clarified that in the event that no risk allowance is paid to civil service officers, there would be no obligation to pay to the judicial officers.
my lord, may I point out, my lord, two things, my lord. Your Lordship may edit, my lord. So far as the medical allowance is concerned, reimbursement, etc., has not been mentioned in the order. As to how it will be reimbursed, nothing has been mentioned. And so far as the higher educational qualification allowance is concerned, they say it will be only one time. If I am LLM, I'll be entitled.
Mr. Sharma, please read our order. Therefore, we made a provision for the disbursement of medical allowances and medical treatment.
So there will be a standard operating
But
procedure.
they are silent, my lord, about the reimbursement, etc. They are silent.
You go to the
And secondly, higher educational qualification, they say it will be only one-time increments. Subsequent promotion, ACP, etc., will not get any increment. Their notification says so, my lord. Is it so, my lord? That was not the intention, my lord. Your Lordship is clear enough.
They say whether a judicial officer is entitled to grant of advance increments for acquiring higher qualification during every promotion or grant of ACP.
That is what.
Yes.
That's also covered para 41 to 40.
That they have denied, my lord.
If they have denied, then that must be challenged. Because what else can I say? Because your lordships,
Application.
Well, in the event that there is any further difficulty in the disbursal of the arrears, in the disbursal of advance increments for acquiring higher qualifications, this may be drawn to the attention of the committee of judges constituted in person
Your
for the order dated 4.
Your Lordship, may I just place on
Including the
record?
medical
This
allowance
actually
issue,
was
my lord.
brought-
Medical allowance issue also.
I have
Including the
annexed
medical
the
allowance.
minutes of meetings dated 5th August 2024. This was discussed. They were not able to resolve it, which is why the finance had actually written to the registrar saying approach this honorable court for clarification. The issue is this, Your Lordship. Your Lordship direction says that 3 advance increments should be given once they acquire a higher qualification and +1 if they get a doctorate. According to us, we've already given that. Now, what the officers are saying is that every promotion they should be given that 3 increment again. This is a controversy, Your Lordship, and this is a genuine obstacle that the state is facing because we have already given.
You have already given it.
Yes, Your Lordship.
They are now saying that for every
Promotion they need to be given.
The normal increment, madam, not the additional increment, normal increment. They say that once you are given 3 increments on attaining the higher educational qualification.
Granted the first ACP, and at the first ACP, all their colleagues are entitled to 1,000 rupees. I'm just giving an illustration. The advance increment is 100 rupees for higher education qualification. So they get 1,100 instead of 1,000. Now the next ACP, my lords, they are all placed at 1,500. So the officers who are claiming this higher education allowance now say that our edge is lost because all of us in the next ACP have been put at the same bracket of 1,500. So we should get it 1,600 also at that point of time because we have actually worked and earned an LLM and a PhD degree so that we are entitled to the higher education qualification advance. So ACP is almost like a matter of, because they are otherwise not promotional opportunities, almost as a matter of course. So they say this edge is lost every 5 years we are granted the ACP because then all of us become par at the next.
It's a one-time payment.
Yeah, that's the opinion of the finance department.
No, the judgment is very clear. Judgment says that advance increment.
1 minute. Your Lordship, just kindly just see the judgment para 41 to 41.
That may also be gone into by the committee then.
No, in this case, she is right when she says that the committee has gone into it. They were not able to resolve it. Therefore, they have filed.
Let's see what paragraphs 41 to 43 say.
Yes.
41.
This matter gets resolved.
Para 41 on this is there. The SNJPC noted that for acquiring higher qualifications in law, specialized study of the subjects concerned is involved, and the acquisition of such qualification, the nature of a postgraduate or doctoral degree, will improve the quality of work of a judicial officer. The recommendation of the SNJPC are summarized below. The para 42. The recommendations made by the SNJP is that the benefit of advance increment shall not be extended at the ACP stage appears to be covered by this order of this court dated so and so, so and so. There is no justification for denying the benefit of advance increments at the ACP stage. The object and purpose of ACP is to prevent stagnation. On the other hand, the object and purpose of advance increments for acquiring higher qualifications to improve judicial performance. Hence, the restrictive condition imposed by the SNJPC in regard to the non-extension of advance increments at the ACP stage is not accepted. The advance increments for acquiring higher qualifications shall also be made available to officers who have acquired the degrees through distance education.
So we said even at the ACP stage.
For the clarification now, they get first ACP, they get it. Second ACP level at 1,500. So at that time also they must maintain their edge.
Different states are interpreting it differently. So, my lord, I suggest we will just collate it and give it because this is not a problem only related to this state. Different states are doing it in a different fashion. So this is a problem across the board.
For promotion also it has been.
As regards the grant of advance increments for acquiring a higher qualification, Learned Counsel appearing on behalf of the state of Nagaland states that the directions contained in the judgment of this court dated 5 January 2024 have been duly complied with. However, the issue as to whether the advance increments should be granted at every
stage of the ACP,
every ACP stage was placed before the committee of judges of the High Court but could not be resolved. Hence, an application for clarification has been filed before this court. Full stop. Both the learned amicus curiae and Mr. Gaurav Banerjee appearing for the judicial services, both the amicus curiae, Mr. K. Parmeshwar,
BK Sharma, I'm appearing for the judicial
on behalf of the judicial service associations, state that this is an issue which concerns other states as well. Full stop. They have agreed to. They have stated that they would prepare a compilation of the position as of the manner in which implementation has taken place of the directions contained in paragraph 43 of the judgment dated 5 January 2024, so that comprehensive directions pan India can be issued. Full stop. The issue in regard to the payment of the advance increments for higher education allowance as regards the state of Nagaland is therefore deferred and would be dealt with on a pan-India basis. subsequently.
Obliged, Your Lordship.
Alan, may I just clarify?
Right, so now,
Apart from ACP for post-graduation also, for a promotion also it has been stopped.
Be covered by
The same
it will
ACP.
be covered by the same
be
order.
covered by this order.
Your Lordship, the
But Miss, we are prima facie of the view that this must be granted at every ACP stage also. It was not like a one-time incentive.
But now for promotion also it has been stopped for Nagaland state.
We'll see. Promotion you have stopped.
Your Lordship, yes, we're just,
That
we've
we'll
just
resolve.
given one time
Doesn't
and that
matter,
is
we'll
about.
resolve it in a short order. It's not a very major thing.
Obliged, Your Lordship.
Now what is
Your
left
Lordship,
is only,
the
Now
Chief
what-
Secretary and the Finance Commissioner also
Yes,
present.
dispense with, yes.
Obliged.
because Meghalaya is done, Himachal is done, Millards. What is left is Haryana. Haryana, only one aspect, Millards, para 60 at page 14. The state of Haryana in its affidavit dated 20th August 24 had stated that it has issued necessary GOs revising pay, pension and allowances. The affidavit stated the following. Further stated that domestic help allowance, medical allowance, Your Lordship will kindly note that, are not extended by the state government to any new pension scheme retirees. So what they did, so far as all the other concerns are, conditions are concerned, they have met, Millards. Pay, pension, areas, all that has been met. But these two allowances, they are saying if judges start retiring under the new pension scheme, they will neither be entitled to medical allowance nor will be entitled to domestic help.
Disappearing. We have to grant this. What is this?
Millards, as far as this part is concerned, Millards, my instructions are, Millards, because this issue specifically, Millards, this is pending consideration because, Millards, old pension scheme, whether.
But this is independent.
Millards, we are already giving it to all the serving judicial officers. We are giving it to the retirees under the old pension scheme. As far as the retirees under the NPS, Millards, for that thing only, Millards, there is a little ambiguity, Millards. With respect to this, Millards, we are saying that whether they will fall.
No other state has this problem.
We'll keep pending.
My Lord may decide this issue one way or the other. This
We'll decide it with the.
Yes, my Lord may decide this one.
We'll decide this issue with the pension scheme.
Please, Millards, please.
The state of Haryana, in its affidavit dated 20 August 2024, has stated that it has issued GOs for revising pay, pension and allowances. The affidavit, however, indicates as follows. Para 60 mein copy kar lo. We take on record the assurance that all other allowances, except for the domestic help allowance and medical allowance, have been paid.
Please, Millards.
They've been paid, no?
Yes, Millards. Even the old pensions, retirees under old pension scheme, they have also been.
Stated that the retirees under the old pension scheme have been paid the domestic help allowance and medical allowance also.
Please, Millards.
Stop. The issue, however, pertains only to retirees under the new pension scheme. Since the issue in regard to the applicability of the new pension scheme is pending before this court, we defer further consideration of this aspect.
In fact, I just wanted to add something in that
Yeah.
regard. The new pension scheme has now acquired certain dimension.
We saw
So
the
that
other day.
You'll not defer it for the time being so that none of those issues are taken up.
My Lord, we,
Very
my Lord may decide this issue of old pension scheme
That's all
in
right.
one way so that, my Lord, this is decided.
Right.
I don't think this tweaking will really help. My Lord.
All right. So now that is Haryana. Now
On compliance,
Orissa is compliance is over.
all is done.
Now we have to, yes, the appearance is dispensed with. No difficulty.
So far,
Now,
I just wanted to point out that Secretary Commission recommendation came in 1999. 2007 is when 99% compliance was recorded. We are much better in terms of the record. 22, your lordships accepted the first set of recommendations. In 24, we are at least 95% compliant. Petty Commission took 99 to 2007, one after the other, coaxing the states into complying with the recommendations your lordships approved. It took 8 years then. The second NJPC has taken much lesser time.
Yes.
2 years time.
Now, what are the general directions that we have to issue? We will say that so the present order has dealt with the issue of compliance with the directions contained in the order dated 4 January 2024 and the previous orders. Full stop. Apart from the above directions, we issue the following general directions, bracket 1. In the event that any individual grievances subsist of judicial officers in any state, this may be brought to the attention of the committees of the judges of the High Court, constituted in pursuance of the order dated 4 January 2024. That's one.
In respect of specific allowances, there are disputes that may go to the committee. There are specific allowances partly implemented, not implemented.
This one above, the direction in one above would also cover any grievances in respect of specific allowances, which should be resolved at the level of the state stroke duty concerned by the committee of judges.
So far as the problems that our judicial officers are facing in terms of withdrawal, etc., your lordships had issued specific directions in para 85 and 86 of the judgment dated 4/1/24. Your lordships will say that the high courts will make that compliant, because your lordships have directed them to have standard operating procedures, put it on the website, say how well they can medical
paragraphs
85 and 86. Those directions, your lordships will just reiterate.
High Court, the committees of judges in the High Courts, constituted in pursuance of the order dated 4 January 2024, shall in particular ensure that a standard operating procedure, as mandated in paragraphs 85 and 86 of the order, is duly put into place in any event by 30th September 2020.
Also said that your lordships will direct them to meet at least once a month or a fortnight.
The 4, in order to resolve all pending issues in regard to the payment of pending issues pertaining to the grievances of the officers, any subsisting issues regarding the grievances of the officers in regard to the payment of allowances, we request the committees constituted by the High Courts to meet once every month so that the grievances are resolved expeditiously. I think we'll say once every month.
My lord, we filed an application seeking your lordship's permission to recommend to the government for increasing the retirement age to 61.
Should we get into that? You can always do that, but you require us to give you liberty.
No, because of the
what will happen as far as Telangana is concerned? It's retirement age to 61. One minute. The government employees age was increased from 60 to 61 in Telangana. So the High Court sat with the government, and the government had an application before your lordships and saying that the judicial officer in Telangana. But that was with the concurrence of the government. The High Court, the judicial officers, and the government was at dialogue, because and your lordship also agreed to it immediately.
I remember that order.
Although this commission had said that it's not going to recommend any increase in retirement age,
that was because the government was willing to do it.
Now there seems to be some concern for the state government.
My lords, may I just take a minute to point out for this?
They have also increased it for their employees from 60 to 61.
In
Andhra. Question is whether that increase also must, the benefit of the increase must also given to judicial officers. There are two reasons why it ideally should be. One, at the district judge cadre, we are now facing an extreme crunch. We don't get enough officers every year for recruitment across, your lordships knows that. Two, all the special courts that the different statutes mandate are all district judges. POCSO, CBI, politicians courts, MPs, MLAs courts are all manned by district judges. So it is something that will actually benefit the system if we increase the retirement age by a year.
There's no reason why the High Court should not take it up with the state.
So the High Court agrees with it. The question is whether the state will now agree with it. Your lordships.
My lords, we have no problem.
The state requested us to send a recommendation.
My lords, if I may explain what has happened. The state had carried out an amendment and increased from 60 to 62. That was set aside by the Honorable High Court in light of my lord's judgment. My lords, therefore, now, as of now, the age is 60. If my lord, for the retirement of judicial officers. My lords, if my lords consider the application of the High Court may approach us and we will consider it in due course. My lords, it is a policy decision and a legislative amendment which must be carried out.
The High Court
You are appealing for the High Court?
Yes.
But why did we set aside the decision of the government to increase it from 60 to?
No, that's for the civil service, not for the judicial officer.
No, my lords, no. For judicial officers, it was increased from 60 to 62. Viday an order dated 16/9/22. The Honorable High Court, relying on my lord's judgment in the 4th All India Judges case, says 62 due to hierarchy of courts. The retirement of a district judge at 62 is not permissible. Whereupon Telangana carried out an amendment, made it 61. High Court approached pursuant to the amendment. In Andhra, there is no 61 amendment, which is why.
So now, therefore, there's really nothing, okay.
Pending there.
The High Court can certainly approach the government of Andhra to increase it from 60
The
to
state
61.
government asked the High Court to send a recommendation for amendment.
Right.
Now, because of the judgment of your lordships, my lord, the High Court thought it fit to seek permission of your lordship.
We quashed the increase from 60 to 62, right?
Yes, ma'am.
Does our judgment prevent the government and the High Court from increasing it from 60 to 61?
No, my lords, in the state of Telangana, that amendment has been upheld by my lords. In state of Andhra, that amendment has yet to be done. We are only asking that the matter may take its due course in amendment. We may be permitted to consider it, my lords.
Your lordship,
Why do you require us to give you a stamp of approval? Let the High Court do it. The Chief Justice is to do it.
your lordship only say that the High Court may send.
Why should we? Something that the Chief Justice themselves have to do. Why do you have to be so?
Because the judgment of your lordships, my lords, in the All India Judges Association says
Look, that said that 62, from 60 to 62, because there has to be some difference to be maintained. Now, 60 to 61 is affected in the case of Telangana. That has the imprimatur not only of the states and the high courts, but our imprimatur also. Now, if similarly for Andhra, if you want to submit a proposal to the state of Andhra Pradesh, please do it. Please tell Justice Thakur to send it across to the state government. We have no difficulty. But you don't require, I don't see why we have to certify that you can do it. Do it. Who's going to oppose it? It can be the state government. It can be the judicial officers. So long as it is something short of 62, why should we stand in the way? Especially because the Telangana judicial officers have got it. Right?
Arose because of your lordship.
That's all right. Now there's no confusion. Have a word with the learned Chief Justice. All right. You can show him the order which was passed for Telangana. Ma'am, why don't you do this? Just share the order which was passed for Telangana with the learned Registrar General.
We will do it, my lords. However, they are aware of it. And they are aware that it's supposed to
You don't require us to. All right. So this part is over now.
Because all this part is over, Millet. Today also your lordship had listed the suo moto so far as the High Court judges' salaries and the fixation of High Court, a number of issues. So I have just put in a note, Millet. Some of those.
Do we take it up today or do we take it up?
Lordship will just adjourn these matters because pleadings are not complete. Just kindly takes the note for a minute, Millet. There is a horizontal. I've just made it easier and put one vertical and one horizontal.
Yes.
Well, this is an entire batch of matters connected with the suo moto. On the last occasion, your lordship had issued notice on the suo moto. There are 3 matters in which I have indicated formal notice has not gone, pleadings are not complete. Your lordships will direct
those.
Oh. Item number 5, 7,
and
15.
5 is refixation. 7 is Hate Singh, right?
Right.
That's Hate Singh Yadav.
That's right.
And 15 is refixation of pension, additional pension.
Right.
So we'll issue notice. They are on board today, right?
They are all on board today.
We'll issue notice. Returnable on kar do. After 2 weeks?
4 weeks, my lord. Let the
4
pleadings
weeks,
also be
Karo.
complete. Let the pleadings also be completed, then we'll.
Pleadings be completed in the meantime.
Look, this can be detagged from the All India judges because this is High Court pension.
Detag this, these are High Court pension matters, all right, and detag it and we list it separately.
There are two employees matters which have also come in the list today. That also will be detagged and your lordship can call it.
Can you just give him the?
We'll give the numbers. We'll give the numbers.
Employees matters detag kar do, wo alag list hai.
1.8 actually.
We'll take it up.
Looking for a very long time.
Yeah, we'll take it up.
Yes.
All right.
Grateful.
Your lordship.
There is 1.17.
That is in this only. The High Court judges fix it.
1.2.
Your lordship.
This is also the High Court judges in the same batch. What Mr. Dwivedi is appearing in. This is
1.17, no, it's a pension matter, my lord, just claiming the benefit of the judgment of your lordship already delivered, my lord,
again, High
Rahul
Court
Garg's
judges.
case.
High Court judges, my lord. Because there are 3 or
Notice
4.
has been issued in that matter?
Yes, notice was issued.
Because the union is contesting, there are 3 or 4 sets of matters in the High Court judges case. One, additional judges who were not made permanent, died in office, family is not getting pension, number 1. Additional judges, if they don't complete the requisite qualification as of qualifying years of service as a High Court judge, whether they are entitled to pension at all, issue number 2. District judges who are under the new scheme, new pension scheme going as High Court judges, which is the lead matter your lordship took so motor cognizance of, because he was not entitled, the gentleman there was not entitled to pension as a district judge because he was under the new scheme and he became a High Court judge. Even after retirement as a High Court judge, they are giving him the same new pension scheme pension and not the pension that otherwise High Court judges are entitled to. So there are 6 or 7 issues. I have tabulated them, in each one. What is the issue? Your lordships will have it because the union is contesting each one of them.
No, in my case, it's squarely covered by the judgment. There's no question of contest in this case. It's on all 4.
I know, but we'll have to hear the other side, right?
The union.
Who's appearing for the union?
My lord, may I need 30 seconds, my lord?
Detag.
My lord, may allow me 30 seconds, my lord?
Your lordship.
My lord, may allow me 30 seconds, my lord?
Lordships have interpreted part 3. We are claiming this benefit as interpreted by lordships. The other thing your lordship
Can
said.
we detag that matter and then hear that? Can just detag that and keep it on another day, on a Friday. We'll see then, so we doesn't get lost in this big bunch.
Only 4 paragraphs your lordship judgment have to pay.
We'll keep it either on next Monday or something.
May I seek my lordship permission, my lord? Mention item number 1.2 to 1.6, my lord. In one of them, lord, the petition of R.P. Mishra, my lord, who is not getting salary for the last 9 months. Lord. He's a sitting judge of Patna High Court, my lord.
Right. We are keeping all of them together. And we'll keep it, because there are some matters where notice was not issued. We'll hear it together in 4 weeks and resolve it.
My lord, what is happening is he's not getting salary for the last 10 months, my lord.
The same problem, salaries.
He's a sitting judge of the Patna High Court.
What the concern is this, they are saying he does not have a GPF account, therefore he is not entitled to salary. It's a very weird case, Millards. They are saying these are officers who are under the new pension scheme. They are working as
Besides that new pension scheme, straight away all this will be over, my lord.
Because they are saying, because these are sitting judges, judicial officers who were born into the new pension scheme, they don't have a GPF account, therefore we will not transfer salaries also. This is a sitting judge of the Patna High Court.
What?
Once your lordship decides that matter, all this will
I am seeking
fall through, my lord.
Who's appearing for the union of India? We'll take it up separately in another, we'll keep it up, dealing this matter, Justice Mishra's matter, and we'll take it up either on Friday or Monday, we'll take it up.
It will take only 1 minute, my lord, if you will take, my lord. Only, my lordship may see page number 63 and 64.
Who are you appearing for?
For R.P. Mishra, my lord, Justice R.P. Mishra.
We are taking it up. We'll take it up. We are not keeping it in the group. We'll take it up next Monday for Justice R.B. Mishra's matter. And who is appearing for the Union of India?
My lords, I am here. Learned Attorney General was leading us, my lords.
Right. We ask him to be here next Monday. We'll take it up.
There are judges. I'll give the numbers of all 3 judges who are sitting judges who are not being denied salary because of this issue.
Your lordship, one more I.
He's not receiving salary?
I need 30 seconds.
Western is not a pension.
30 seconds, my lord.
Because you were born into a cadre which did not have a assured old pension scheme. You don't have a GPF account. Our software does not provide for giving salaries to a person who does. That is what I am saying. This is
it's for Friday. We'll take it up this Friday.
Very well.
Your lordship.
Take it up.
One more.
Because tomorrow, Wednesday, Thursday, we are in a CB. So we'll take it up on Friday.
Your lordship, one more application.
I am not getting pension since 2014. Notice has been issued. That also may be tagged along with this.
No, that's a district, that's all India judges.
That's an all India judges issue. These High Court judges, we'll take it up on Friday. Let's at least start clearing. Otherwise, if everybody asks for tagging, nothing gets disposed of. At least let's deal with these two matters, Mr. Dwivedi's matter and this matter. We'll deal with it this Friday, and then we'll see how best to move forward.
My lord, we'll have to fixing some date for.
Good time table. We can look at it then.
Deeply obliged.
May I circulate a 3-page note?
Yes, please. That will be on that day. You can give it to us.
In that case, my lordship may direct, my lord, that item number 1.3, 1.2, 1.3, and 1.5, my lordship may be taken on Friday, my lord, because all pertains to the judges of the Patna, sitting judges of the Patna High Court and Allahabad High Court.
All right.
1.2, 1.3, and 1.5. I'm grateful.
1.19 to 1.19.
What is that?
I'm appealing in 1.20.
What is that?
That is also retired judges.
Panisha, what are those matters?
Those matters are, there is a.
From Madhya Pradesh.
Fixation of pension for those judges who came from the district judiciary into the High Court. Their pension is now fixed lower than the judges who are elevated from the bar, because the same concern, this old pension, new pension scheme. So at some point of time, because your lordship will decide that old pension, new pension scheme, then all this will fall into place. Essentially, my lords, in all these petitions, the argument is for one rank, one pension. Whether you have served as a High Court judge doesn't matter from what rank you become
a High Court judge, you get the same.
You are entitled to the same pension as any of your colleagues are concerned. That essentially, that's the short point. If that point is decided, let's
that up also immediately.
That is item number 1.15 also, my lord. The same, my lord, the district judicial.
I will give the list, Millers. I'll give
Just
the list.
give the list. Permission will give it. But make sure you keep Mr. Dwivedi's matter and RB Mishra's matter first and second. We'll at least take it up, then open the others.
That's 1.15. I'm appearing for the CAG. There's a gap. There's a gap between the service before got promoted.
There can't be a difference in pensions of two people born in the same cadre. Can't be that some High Court judges get one pension, other High Court judges get another pension.
Already covered by my lord's judgment on the Rahul Justice.
I'm going to start number 3, no? You just take up.
My lord, I have prayed for 30 seconds, my lord. My lord, in the Kerala, my lord, the state has issued a notification. Whatever you were getting on 31st December 2015, that would be multiplied by 2.8, my lord. This is not correct, my lord, because that payment has to be revised. They have not done it, my lord.
Committee.
This is one thing, my lord.
It's for the allowances.
No, pay.
Pension, my lord.
Why, have you taken it to the Committee of Judges?
My lord, your order.
My lord,
because, otherwise 32 will become what? Look at, we have spent 2 hours in the morning only doing this on a Monday. That's why we've institutionalized it. Leave something for the Committee of Judges in the High Courts. They are right there. They should be taking this up.
We have given that representation, my lord. Thereafter, we have filed a content petition, my lord. My lord has directed the Chief Secretary to come, my lord. That has been disposed of. But this is the fact, my lord. This is for the Kerala, my lord. And then, my lord, Jammu and Kashmir, my lord. Jammu and Kashmir has notified 1996, my lord.
Why don't you go to the Committee of the High Court and have them look at it? That's why we institutionalize the process. Everything for every individual state, we start dealing with these individual grievances. It's impossible for us to. Ordinarily, you have to find a 226 petition. Now, just because there's some petition pending, everybody comes with IAs. We have therefore institutionalized the process by constituting committees of judges in the High Court. Surely, there has to be some faith in those committees. We have said we'll meet at least once a month.
My lord, the committee.
All right, we'll just rise for 5 minutes. We'll take up skill number 3.
Just one, sorry. I'm very sorry. Item 2 has been wrongly tagged with item 1. It has something to do with pay revision of the staff of the High Court, which is at par with the Secretariat.
So 2 has to be delayed.
And it is the admitted matter of 2017.
2 has to be delayed.
2 has to be detagged. It's my respect.
Yes.
Where you like?
I may just make a prayer, my lord.
1, 2, 3, 4, check. Check, check.
सुनो आज एक हमारे जजेस का
Mate, please, Your Lordship. Lordship, one submission, Your Lordship. My senior is appearing in item number 2, Your Lordship. Kindly.
appearance you want to give, right? Appearance you want to give.
No, Lordship, he want to speak something, Lordship. He's appearing online, Lordship.
Yes.
Your Lordship, please, my lord. I'm representing the respondents, my lord, in the matter at serial number 2.
Yes.
My lord, this case had already been directed to be detagged, my lord, by an order dated 25/1/23, my lord. Page number 8 of the order, my lord, this had already been directed to be detagged. This pertains, my lord, to revision of salary of the assistants working in the establishment of Patna High Court.
You know that. Therefore, we have detagged it right now.
My lord, my only request, my lord, would be that it had been listed this time, my lord, on the basis of the mentioning that had been allowed. We had circulated that, my lord, and on that basis, so my only request, my lord, will be that it may, considering that a number of them.
All right. Yes. We'll keep it on a non-miscellaneous day because we can't deal with it on a
Only
miscellaneous.
request will be that considering that it had already been, as in this has this time been directed to be listed on the mentioning that was done, my lord. But due to some confusion, it seems to have been listed along with the matter at serial number 1.
Not listed on a non-miscellaneous day.
May it please, I had approached the Honorable High Court seeking bail. In a the maximum punishment of the offence is 5 years. I've spent about 1 year, 3 months. If your lordship, I'm so sorry. Please have the impugned order and the reasoning, my lord, which begins at page 3.
You are in custody since how long?
1 year, 3 months, my lords, I have spent in custody. And the allegation was page 3, the last 3. I'm so sorry.
The petitioner, the bail application filed by the petitioner in miscellaneous criminal case, namely miscellaneous criminal case number 19442 of 2024 was dismissed by the impugned order dated 1 July 2024. Let's stop. FIR number 201 of 2023 has been registered against the case stand number 201 of 2023 has been registered against the petitioner for offences punishable under sections 3 and 5(1) of the UP Prohibition of Unlawful Conversion of Religion Act 2021, sorry, and section 365 of the Penal Code 1860 at PS Modaha, District Hamirpur. But stop, the petitioner is in custody since 21 May 2023. Let's stop. The charge sheets have been submitted.
Charge sheet is submitted, 365 has been given up. So the sole offence surviving now is of the Conversion Act.
Then counsel appearing on behalf of the petitioner submits that while the charge sheet has been submitted, there is no, the offence under section 365 of the Penal Code has been given up.
Charges have also been framed.
Let's stop. Moreover, charges have been framed. The petitioner next. The petitioner is in custody since 21 May 2023. So we see no reason or justification for the continued custody of the petitioner. Hence, we issue notice returnable on Kardo, liberty to serve the standing counsel for the state of Uttar Pradesh. Next, pending further orders, the petitioner shall is directed to be released on bail, subject to such terms and conditions as may be imposed by the then trial court in connection with case crime number so and so.
I'm most of that. Most of that.
Take this and keep it separate papers.
May I please?
Yes.
I had given a written note, my lords. Lordship may kindly say this. On 13/8.
Who's appearing for the other side? Yes.
Yes.
Just give us a note, please.
This is dated 13/8, my lords.
One second.
Well, I got a spare copy as well. Court master. Court master.
To this, we'll take up run through. We have a few fresh matters. We'll
Very
just
well.
run through those and then we'll start with your matter.
Very well.
That's better.
Very good.
Five we will just take up after the fresh matters are over. We'll just take some of the fresh matters.
Just have one paragraph of the impugned order, page 18, which is PDF page 49. The impugned order recognizes that there are various issues of fairness and relating to the scheme, but then it says we will not go into any of those issues because you don't have locus. But the test which your lordships have laid down is, irrespective of whether I have locus or not, when a court is approving the scheme, they have to look as to whether the scheme is fair, whether it is conscionable to the minority shareholders, etc. Please see page 18.
No, but it cannot be then inquired into at your behest. That's the point.
Very well, but this is when I have come, I'm less than 10%, your lordship, admittedly so. Under section 230 subsection 4, it's only 10% who can raise an objection. But your lordships have said that even if
but then how can you challenge today that order? Because I will quite see at the behest of somebody else, we can look into it.
May I, because the court,
otherwise, if we consider your appeal on merits today,
yes,
we will be really bypassing the requirement of a 10% voting.
May I answer that, your lordship? Because when the court itself has recognized that there are issues and framed the issues, please see para 15 for a minute.
You are challenging the judgment on merits. As far as you are concerned, you have been shut out only on the ground.
I'm trying to answer your lordship's question, if your lordship gives me indulgence for 1 minute. I'm saying that the court was cognizant of the fact that there are issues in relation to the swap ratio, issues in relation to the valuation, issues in relation to that the effective date is effectively 2 years after the valuation date. The court was cognizant after those arguments have been recorded. The courts have recorded that these are the 3 issues and made an issue on locus also. So what I'm saying is, let us say on locus, even if they had said there was no locus, the court in relation to the conscionability of the scheme or the fairness of the scheme should have looked into whether the approval was valid or not, whether it is fair to the minority shareholders.
99.33% of the equity shareholders and 90.93% of the public shareholders.
Your lordship, I may answer that because the public shareholders...
Now, at the behest of a person who does not meet the threshold, why should we...
May I answer both, your lordship?
What do you have to say? Yes, anyway, we got your point on merits.
Yes. May I just take 1 more minute, your lordship, before my learned friend hears? Yes. Your lordship, the question of the 99%, even though at first blush, that seems very appealing, those were more institutional shareholders who were already bound by the previous resolution plan approval between your lordship Bhushan and Tata. So these are the individual shareholders, and there are more than 4 lakh individual shareholders.
One has infused about 36,400 crores now.
Your lordship, I am only on the point. Just 1 minute, if your lordship indulges me. The swap ratio.
Once 36,000 odd crores has been infused for the purpose of revival.
But your lordship,
we act today at the behest.
No, the court has
doesn't meet the threshold.
Your lordship, the court has also recognized that it is not that we are challenging the scheme or saying the scheme should be reversed, but the individual shareholders are getting.
Dr. Singh,
there is, I say with great respect, there's a limit to how much your lordship's process can be abused. Just don't open pages.
There are 17 of these persons. They are punters who purchased after the amalgamation. The idea of purchasing after the amalgamation is to try and extract. For this reason, your lordships amended the law. My lord, when we started practice, your lordship didn't have this threshold requirement. Lordship, remember, you had it only for the oppression. They amended the law in 2013 Act to put it here also, precisely for such persons, that you must have a minimum threshold. His threshold is 0.69%. So what he does is, 0.06, I'm sorry, 0.06. Now what he does is, he says, I will first carve out a 1,000 persons group, then I will say I'm 593, but not count the value. The test of 234 is by value. So, and concurrent findings in my favor, this is the original dirty dozen group, which your lordship went up to the Supreme Court and upheld the IBC. In the IBC resolution plan of the original led up to Supreme Court, there's a clause that after this plan, we will amalgamate or merge. So he's actually now negating it as a fresh buyer. 11 of these 17 did not participate in the voting also. Now they come here suddenly, and they came, I don't want to say this, they come, there are, as your lordship knows, absolute bar 60 plus 60 days. They come they come one day before the second 60 days, but they file something without a single document, not one document. Your lordship have a judgment on this, that just to save limitations and afterthought, you come on the last but one day and file no document. The actual documents are filed 2 months later, so well beyond limitation. Lordship knows these are those acts where lordships can't extend limitation. Lordships can't in these acts. But this is not a case for lordships to interfere. And when all the money has come, the plan is implemented for the last 7 months.
May I take just 1 minute in rejoinder, lordship will allow me. Just two facts and I leave it to your lordship. Just 2 minutes, your lordship. Your lordship will appreciate I am not saying reverse the scheme. The swap ratio, we have got 1 share for every 15 shares. Whereas the turnover, if your lordship is only 3 times.
You acquired shares after the amalgamation.
No, that is not correct. Some people have come afterwards who jumped onto the bandwagon, but it is not the entire group.
Why should we interfere at the behest of people
14 out of 17
who have jumped into this
your lordship, there are constitutions.
Why they purchased it after the amalgamation?
Lordship, but I am saying even at the behest of the petition who were already there, lordship will consider only one indulgence. May I put forward a request?
Dismissed, yes, sorry.
Lordship, may I put forward a request? That if it's limited to examining the swap ratio, because that will benefit.
You have to open the door with the minimum threshold to argue that.
Your lordship will consider that. Your lordship, in 2 judgments, Sesa and Hindustan have said the courts will look into fairness and conscionability vis-a-vis the minority shareholder.
Inquire into that aspect, provided we have people who satisfy the threshold.
No, that your lordships have said. May I take 1 minute? Your lordships have said even if the threshold is not met, in approving a scheme, the court's duty is to see where fairness is.
Who can challenge it? Not a person who doesn't meet the threshold. And on these facts, when you have joined up with people who purchased shares after the amalgamation.
They have joined with me, but if your lordship would consider that even at high behest, the ones who were originally shareholders, only limited to the swap ratio, because otherwise the turnover, your lordship, of Tata was for the last financial year was 9,000. Ours was nearly 3,000. That is a 3:1 ratio, your lordship.
Item 7. One person per matter, one counsel per matter. Yes.
Obliged, your lordship.
Lordship, item 7 is the school batch.
We'll have to.
Lordship will issue notice and tag with the main batch.
We'll issue notice and
But
tag.
Lordship, I have a small submission. The matters are shown tomorrow. But tomorrow,
They are in the CBC.
yes, Lordship. So Lordship may
reschedule.
reschedule the date.
All right. At an early date, we'll take it up after the CBC.
Lordship may have it at the end of September.
Item 8.
This is Tola matter, your lordship.
This is Tola.
Item 8, 11, 18 and 20.
18 and 20, right, Mullah. This will have to be, Rajiv Bansal will have the direct bearing on this one.
Yes. 9.
Item 9, Lord, the notice has already been issued in a connected matter. There is an office report.
We have issued notice in the connected matter just the other day. We'll issue notice and tag you. For that extension of time for you to pay the balance. We'll see what. Yes.
10 also, Lord, these matters are pending. Your lordship may issue notice and tag.
Notice and tag.
Lord, your lordship may also say no coercive step because your lordships have already ordered that in 2nd of August order, my lord, arising out of the same impugned order.
Same order.
Same order. Obliged.
Well, your lordships may please pass the same order as your lordships done 20th of August. That's the main petition. Your lordships have already issued notice.
12 is an arbitration petition.
Yes, my lords. Your lordships have already done it for 3 others.
Yeah, कब का हो गया? गंगा के नीचे वोट चली गई अब yes 12 is an arbitration.
Yes, my lord. Same order as on 20th of August, your lordships have passed already.
In arbitration petition 42 of 2024 and 44 of 2024. So it will issue notice and tag with.
Grateful to your lordships.
Also, this is also was
This
doing
is
on
also
SSC.
school batch.
This is that school batch 17, 13.
Great.
14.
I'm seeking a short pass over you.
Concurrent finding here. Yes. Nothing. Let's tell us what is the matter about. Tell us.
Yes, very well. The matter, it arises from a development agreement. Now, at the instance of a developer, your lordship, the landowner is being put to insolvency on account of refund of security deposit in relation to a project which was never performed. Now, the developer itself is in CIRP and there is a successful resolution applicant who has filed a resolution plan where he undertakes to perform the project.
Yes, Mr. Secretary.
Now, in these facts, I'm led by Mr.
Now, the Mr. Shankarnarayan,
Yes,
which says that the corporate debtor showed the amount of rupees 3.5 crores plus interest as long-term borrowings till 13-14.
Correct. That's correct.
Right? Now, could not deny the existence of the financial debt.
Yes. Now, the first question is there a default? Even if it's accepted as a loan, etc., which is what it has been accepted at to a certain period, the initial amount of the security deposit was 12 crores. Over and above that, 3.5 crores comes in. If I can show your lordships that clause, just page 8, where clause 8 is set out. Lordships have that? 8.1, if I can just read the last 6 lines of it. The said sum of 12 crores agreed to be paid by the developer will be treated as a security deposit. However, any further sum subject to a maximum of 3 crores, this is accepted, that's went up to 3.5, if advanced by developer to owner, shall form part of, I'm sorry.
Yes.
Shall form part of security deposit and shall carry interest at agreed rate of 18% per annum, compounded and payable quarterly. Now, this entire amount of 12 plus the balance had to be repaid at a certain point of time. What is that certain point of time? As per clause 8.1, there is a schedule. It has to follow that schedule, which means there are benchmarks by which the project would be completed. Now, when you don't lay down a single brick, none of these benchmarks are met. So, the security deposit repayment that is due, and I'm admitting that I must pay it, but the question is when? That is what the question of default is. Here, even when I admit that it is shown on my books and I show it to a certain date as a loan that is outstanding, I'm anticipating that the builder, Avni, is going to go ahead and construct on my land. That doesn't take place, nothing is done. Avni goes into insolvency, the builder. When it goes into insolvency, a strand from that comes all the way up to this court, and this court holds that the development rights that Avni has is an asset in that insolvency and invites a resolution plan. The resolution plan is to discharge the obligations in this agreement which I have with the builder. How is it possible for Avni, just prior to going into insolvency, to file a claim like this, saying that there is a default by me when Avni is the one who has to carry out the constructions? Today, the scenario is that we have 2 resolution plans which are in place. One resolution plan, the other one is mine, where it's expected. In one, the same agreement is being acted upon.
Ultimately, you showed this really as something which was due and payable by you.
Only till a particular date, after which I say it's no longer and it's not shown on my books. That's the second point that I was coming to. If your lordship sees the regulation 2A, which is read with section 7.3, just come to the synopsis, page D, my lords. Page D. This is an absolute mandatory requirement for section 7 to be triggered under the code. Just see page D. Section 7, as your lordship knows, that proof of default has to be specified, shall be as specified. Page D. We have set out regulation 2A.
Why do you continue to make an acknowledgement of debt? Admittedly, there's an acknowledgement of debt due by you in your financial statements of 13-14 14, 15 and
17, 18. Yes.
17, 18, 18, 19.
18, 19, all.
13, 15, there is a note.
But we have a qualification. Same page D shows you the qualification at the bottom of. Just see page D, Manoj.
The argument is really that yes, we showed it as an outstanding due. This was given, this 12 crores was given, but this was conditional on your performance of reciprocal obligations by you, as you are the developer.
Yes, my lord.
He is the landowner.
Yes, my lord.
He says this was conditional on the performance of reciprocal obligations by the developer, which you failed to discharge.
So with great respect, my lords, the answer to that is this. There are two elements to the security deposit. One was 12 crores of rupees and the other was the 3.5 crores, 3 crores which was. There was no interest attached to the earlier 12 crores of rupees. That was security for my development. But 3.5 crores came with the clause separately, which said you have to pay 18% interest quarterly. That quarterly runs from the time that I disbursed the 3.5. Admittedly, and this is the finding of both the courts below.
12 crores.
Yes.
Your notice was not in respect to the 12 crores?
No, it was not.
No, it's
Clearly,
a
it was only
3.5.
for, please see, part 4. Yes, I'll answer that question.
Can you in that sense bifurcate can you bifurcate their liability in respect of 12 crores?
Yes.
From their liability in respect of 3.5 crores?
So the development
Does the agreement say that
Yes, my
3.5 crores is returnable irrespective of what happens to
Yes,
the
my lord,
developer?
your lordship will see. So that, my lord, is the clause. The clause says very clearly.
Let's read the clause.
Yes, my lord. And if your lordship has page 10 for a minute, just to answer the first question that my lord posed.
The judgment of the NCLT.
Yeah,
right?
judgment of the NCLT.
Let's see page 10.
Yes, my lord, page 10. It just begins at the page prior to that, my lord. If your lordships has just page prior to that, para 14. To answer that question.
Yes.
The development agreement in clause 8.1 as extracted above, rupees 12 crores has been referred to as the refundable deposit, which does not carry any interest, which was treated as security deposit. The clause further states that any further sum subject to a maximum of 3 crores, and this was amended to 3.5 crores, if advanced by the developer to the owner, shall form part of the security deposit and shall carry interest at the agreed rate of 18% per annum compounded and payable quarterly. Thus, the further sum, in addition to 12 crores, was given a different treatment and it was treated as an advance by the developers, which was part of the security deposit, but was to carry interest at the agreed rate of 18%. 8.1 uses the expression carry interest at agreed rate of 18% compounded and payable quarterly. Thus, the interest of 18% was payable quarterly, which was unrelated to the security deposit of 12 crores of rupees. Clause 8.2 deals with the refundable deposit and 8.3 recovery of security deposit in case he fails to. In the present proceedings, we are not concerned with 8.2 or 8.3 since the application which was filed by the financial creditor was not for the refund of the security deposit of the 12 crores or even the 3.5 crores. This is limited only to non-payment of interest, my lords, which was quarterly due. That is clarified in the column. Part 4 requires statutory. Yes, may I read this? Part 4 in column 2 with regard to the amount claimed to be in default and the date has been stated. Amount claimed to be in default. May I read part 4? Total amount of claim to be in default is 10 crores 90 lakhs. The above amount of claim is only, my lords, no refund, no security deposit, only interest. Interest portion at 18% per annum compounded and payable quarterly till 31st August 2019, excluding the principal amount of 3.5 crores. So we are not even claiming, which your lordship mentioned.
The only point which you let's just wait for a moment over here.
Yes.
12 crores, your claim is not on 12 crores.
No.
Before the NCLT. It's
is
not
not even on
3.5 because 12 crores is treated as a security deposit.
Yes, my lords.
3.5 crores is refundable with interest at 18% per annum, right? 12 crores, there's no provision for interest. That's your whole case.
That's right.
Now, that 3.5 crores
is also not being claimed here.
Right, because that becomes a part of the security deposit.
Yes, it is also not being claimed. 12, neither 12 is claimed, nor 3.5 crores.
But if the principal of 3.5 crores becomes a part of the security deposit,
yes,
can there be an independent claim under section?
With great respect. Yes, my lord. There is no claim even in respect of the 3.5 crores. If your lordship sees this paragraph here, Now, on the 3.5 crores, there is a financial liability, recurring liability every quarter of 18%, 18%. That 18 rupees which has to be paid as interest alone is
That is independent of the 12
It
crores.
is
of the
independent.
3.5.
That is the liability. It is limited only to this. This amounts to more than 1 crore. If it is more than 1 crore, then, my lords, that's the end. That is what they have held.
Yes.
That interest of 18% on the 3.5 crores is an independent liability which you have to pay anyway to him.
Only on the trigger of them actually discharging their obligations under the same contract. Now, what the tribunal and my friend are saying is that clauses 18
That's
to...
an unconditional liability which you assume to him to pay that interest of 18%.
No, my lord, just see clauses 18 to...
Interest, that's why I was worried. And I asked him this.
Yes.
Mr. Srinivas, I asked
Yes.
Sanjay this. Does that 18% interest become a part of the security deposit? That may not be a correct reading of the contract.
No, we're not saying it becomes a part of the security deposit. We are saying that I'm admitting that this is a due from me. The question is, when does the default arise? The default arises at a stage when...
Default arises the moment
quarter.
you don't pay it every quarter.
Every quarter.
On the security deposit.
The contract does not say that.
If you just see clauses 18.2 and 8.2 and 8.3 at page 8. Otherwise, it's meaningless to give me this money.
Can you just read out that relevant clause on the interest? 8.1.
8.1.
Just read that 8.5 and the whole of the clause actually.
Hold refundable deposit 8.1. I'll just read that. That's at page 8. The developer will keep in deposit with owner a sum of 12 crore, hereinafter referred to as the security deposit, which will not carry interest and will be payable and refundable in the manner as would appear from part 1 of the 3rd schedule hereunder written. The developer is on date has already paid 7.86 crores. The said sum of 12 crores agreed to be paid by the developer will be treated as a security deposit. However, any further sum subject to a maximum of 3 crores, if advanced by developer to owner, shall form part of security deposit and shall carry interest at agreed rate of 18% per annum, compounded and payable quarterly. If I can read 8.2 and 8.3, because the tribunal says 8.2 and 8.3 don't apply to this amount. 8.2, refund of refundable deposit. The security deposit shall be refunded by the owner to the developer in the manner provided in part 2 of the 3rd schedule, applying to the entirety of the security deposit to 12 plus 3.5. The owner agrees to ensure timely repayment of the said refundable deposit in the manner as hereinbefore stated, and in the event of failure to refund an interest at 18% per annum compounded quarterly shall become payable calculated from the due date of refund.
So it shows that the payment of interest at 18% is an independent, is a separate liability
which will be calculated from the due date of refund. I'm sorry, my lords. Just see, shall be calculated from the due date of refund. Which is the due date of refund? Their stand is, the minute I give you the 3.5, you have to start refunding the amount which is the interest on that very day. From that day onwards, the clock starts ticking.
When does the due date of refund
Yes, just see page 9. Page 9. That annexure is there. The manner of how this has to be repatriated is laid down here. Part 2, manner of refund of deposit. This deals with 4 components, which are the make up 12 crores. And the first part is simultaneously upon completion of foundation of blocks and certified so by the architect. The second is 50%. Third is on total superstructure. And the final is on completion of the project.
Now that we are really concerned with the 3.5 crores.
Correct. We're concerned with the 3.
Right. Now 3.5 crores becomes a part of 12 crores, the security deposit.
That is correct.
But it says the refund would trigger from the due date.
So
the due date will be for the 3.5 crores.
At the least, it would be the first stage at page 9. At the least, it would be the foundation stage. At the most, I could argue that it's only upon completion. I'm not arguing that. At the very least, it should be stage 1. At the very least, he could very legitimately come here and say, look, the due date under 8.2 has started now. He and the tribunal say 8.2 and 8.3 don't apply at all. As if there is no due date then which can be reckoned.
Provides another mechanism.
Just see 8.3 for a minute also. Just see 8.3. 8.3 at the bottom of page 8, Manoj. I'm sorry. 8.3, recovery of security deposit in event the owner fails to refund the said within 7. Yes.
You know, there are two references to 18%.
Yes.
One is in 8.1.
Second is in
the other
8.2.
Now,
Yes.
8.2, my
Yes.
brother just, Manoj just rightly pointed it out.
Yes.
That word from the due date of refund
Correct.
is used in 8.2.
Yes.
Yes.
8.1 does not use that expression,
Correct.
due date of refund.
Correct.
Therefore, the liability to pay interest on 3.5 crores
Yes.
is not tagged to the due date of refund.
And there is one more reason also.
It says in the event of failure to refund an interest at 18% per annum, compounded quarterly, shall become payable calculated from due date of
That
refund.
is in addition to what is referred to in.
It is. That's what I'm
We are
saying.
now dealing with the basic obligation to pay interest at 18% on the quantum of 3 crores.
Second.
Yes. Just see 8.3 also. Recovery of security deposit. In event the owner fails to refund the said security deposit within 7 days of the same becoming due, then in that event, developer shall be entitled to acquire and or buy back such portion of the owner's allocation for repayment of said security deposit at an agreed rate of so and so. And it shall stand reduced. They've always treated this as long-term borrowing.
There's one more
Just
reason.
1 minute.
And there is one more
Just see
reason,
page-
Manoj. If your
just
lordship
see
looks
page
at
D.
the
I haven't
clause,
finished.
3 crores, 3
Manoj,
crores,
just
3
see
crores,
page
3
D.
crores.
Just
Ask
see
those
page
12
D for
crores,
a minute.
Manoj. The refund will
Reference to the 3.
Which is
not-
why,
it's not-
which is why all the more reason. Just see.
But we assume in their favor
Yes.
that 3.5 crores also becomes part of the 12 crores.
It is.
Yes.
Assuming that is so, the liability to pay interest is independent.
It's independent. That's the
And
finding.
that is not deferred.
That's right.
Until the liability to effect refund of the 12
12
crores.
crores is due. It can't be, Manoj. Otherwise, there is a
If you just
quarterly,
see
Manoj.
page D for a minute, page D, I just wanted to show you the regulation.
That's what we wanted to know as to whether the interest liability is also deferred until the liability to pay the refund is triggered.
It's only when it's because it's a security deposit. The question of refunding the security deposit with the interest that is carried on one component of it will also be when it's due. Just see a second.
Correct you. Thank
No,
you.
the second point, page D.
What is the second
Page
point?
D.
D.
Page D for telly. In the synopsis itself, we have extracted it. This is as per section 7, which says that the proof of default is as specified. Now, regulation 2A of the IBBI regulations provides these two proofs. A is a certified copy of entries in the relevant account of banker's book that they have not furnished. B is an order of a court or tribunal that is also not furnished.
Position that 3.5 crores is no payment.
Just see the bottom of the page.
Yes.
Bottom of the same page, page D, your lordship sees the quoted portion, last 4 lines. This is what the qualification was. This is not a complete admission. Since the project has been delayed for over 7 years, the company is unable to pay interest on such unsecured loan. Hence, the management has taken the decision that interest shall not be provided for the year under review, and the company has intimated in writing to the lender in this regard. And then in their books, in the lender's books, also it is wiped away. In their books. That we have, Balots. That's at page 136. Page 136. In their own books. They also don't treat it as a default. Page 136 is their account book.
Case of your acknowledgement. Now, you know, this was a standalone obligation, which was not, this never became a part of the security deposit.
But I qualified it very clearly by saying no interest on that amount. I made it very clear. Very well. I'm great.
No subscribe. Item 15.
Great.
Please, my lords. Item 15, my lords, is a statutory appeal which arises out of the Electricity Act, my lords. Under the impugned order, my lords, the tribunal has held that a force majeure event which affects a generating company also absolves it from paying any transmission charges to the CTUIL, which is what the appellant is, my lords. I own the interstate transmission system. I provide open access into the system on payment of transmission charges. On an earlier occasion, my lords, in a dispute between the same parties arising out of the same issue of force majeure, the tribunal had held that no, the generator is not absolved from its liability to pay the transmission charges. And in case the generator is unable to use the system, then it can relinquish the access and come back later as and when it is in a position to use the system. This time the tribunal says that no, the force majeure events are different. The earlier event had occurred before the commissioning, now it is occurring after the commissioning. And on this ground alone, it says that no, the liability to pay transmission charges cannot be fixed on the generator, Malad. And this is also when, Malad, in my agreement with the generator, there is no force majeure clause. And what happens with the generating station, I am not, there is no privity of contract so far as I am concerned with the generator, Malad. So therefore, Malad, it raises this substantial issue, Malad, whether the generator is liable to pay the transmission charges and relinquishment charges in case there is a force majeure event which is affecting the operation of the project, Malad, and whether the tribunal ought to have followed the earlier decision which it had rendered between the same parties on the same issue. There is no interim application in this, Malad.
Yes, yes, Ms. Dewan.
Well, it's a very well-reasoned order. It's a very simple point. There was a force majeure event. The force majeure event was that there was three people, in fact, died. There was a pen stock which collapsed, etc. And immediately 2 days later, the local administration under a subdivisional officer, which is annexed, said that you cannot do any construction, no work, etc. to be done at all. Now, this is, as your lordships have seen, the transmission utility. So for that particular period, we could not do anything at all. In those circumstances, there is a force majeure clause which is admitted. Now, once there's a force majeure clause, it has to be given some content, some meaning. It means that briefly or temporarily, I am suspended from my obligations. What they are now construing it is that even though there's a force majeure clause, even though the tribunal has come to the, APTEL has come to the conclusion that there is a force majeure clause, still your liability is absolute. Now, that can't be. Some content and meaning has to be given to.
What about the previous order?
Yes. So now in the previous round, let me just tell you, we had at that time, there were strikes. There was a strike. And while tunneling, there was some geological problem. Well, it was so those were held by the tribunal to not be force majeure. It was held not to be force majeure. So I lost on because the strike and all, they said, sorry, you can't take advantage of that. And the tribunal has followed its own decision, which it has quoted as well. Your lordship will see.
NPL power.
Yes, that's right. So, my lords, this is a very reasonable construction, my lords. Once there's a force majeure, there has to be some consequence. It can't be absolute liability. Yeah. Yes.
Come to page 37, Mr. Dewan.
37?
37, para 66.
Yes, certainly.
Force majeure.
Yes. '66.
Yes.
Yes, you're right. So there are two agreements, my lord. So I'll just place them. There were two agreements. Both of them had a force majeure.
TSA and BPTA.
Yes, that's correct. So I'll just place it. I'll just read it. Force majeure means any given or circumstance or combination of events and circumstances, including those stated below, that wholly or partly prevents or unavoidably delays an affected party in the performance of its obligations under this agreement, but only if and to the extent that such events or circumstances are not within the control, directly or indirectly, of the affected party and could not have been avoided if the affected party had taken reasonable care or complied with the prudent utility practices. And in the other agreement, no party shall be liable for any claim for any loss or damage whatsoever arising out of failure to carry out the terms of the agreement to the extent that such a failure is due to force majeure events such as fire, rebellion, mutiny, civil commotion, riot, strike, lockout, forces of nature, accident, act of God, and any other reason beyond the control of the concerned party. The full clauses are also there. I should just indicate in the paper book. And if you like, I can take you to those as well. Force majeure is at page 297. The entire, it's a 2.5-page clause. Clause 14, 297. Because our essential point is that having come to the conclusion that this is force majeure, some content has to be given. Manoj. How can you say that it's absolute liability?
There they had held the devil.
Yeah.
Finding in this case that this operated as a force majeure event.
Yes, that's what the APTEL has come to that conclusion.
But
So you see what happened was that before the original
there was
authority.
an accident at the site.
No, Manoj, yeah, there was an accident. In the sense, what had happened was there's a section of a waterway called a penstock, and there was some damage over there, and a huge amount of water gushed, etc. And 3 people, I understand, also passed because they were swept away. Now, immediately after that, and we placed that communication has also been placed on the record. There was a direction at page 377. Just go to 377.
70.
Please go to A11, 377.
Yes.
Do your lordships have a communication of 20th November 2015?
That would be annexed here.
A11.
Yes.
Accident happened, your lordship has that? Subject, accident happened November 18, so and so, at Sorang Hydroelectric Project. Your lordship has that? Subject?
Yes.
Correct? Now it's addressed to my general manager. With reference to the above, you are directed to stop project work with immediate effect until the inquiry is completed, compensation is paid, and the person who lost
really holds it for this period. There was no liability to pay the transmission.
No, so all we said was that, look, once we were completely shut down because of these administrative directions, etc., force majeure applied because it was not beyond our control, not anticipated. So a general notion of transmission charges which have to be paid would not arise because force majeure must absolve me of some obligation. That's what the clause it specifically said. So all the APTEL has done is that, look, there is a force majeure event. We are satisfied by it. This is not. Force majeure.
Power limited relied upon was carried to the Supreme.
Yes, it is pending.
Yes, Malaj, yes, Malaj. We have filed an appeal, Malaj. And may I say this, Malaj? Ultimately,
sorry, there's just one factor I'll mention.
PL is relied upon over here.
No, true, but just see the findings because this to answer your question, para 62 and 63, which I believe is at page 36. Findings of the APTEL on the question which you put to me. If you see impugned order, I'll just read it. We are satisfied that the directions issued by the government of Himachal Pradesh in the light of the large-scale damage caused to human life and property. The work of the project site was put to a complete halt. In fact, the aforesaid unforeseeable accident, which was beyond the control of HSPPL, the commissioning of the plant has to be halted completely as per the said directions for stopping the construction activities during the pendency of the investigation until such time the rehabilitation of the affected village is complete. And therefore, the appellant was not in a position to commence operations repairs of its plant. The copy of the letter of 20th November 2015, vide such directions of the subdivision was placed on record. Para 63, undisputedly, the appellant was forced to halt the operation.
It seems to be overall a reasoned and a balanced order.
Yes, Malaj, ultimately.
Malaj, I have 2 submissions to make, Malaj, on this.
Case.
That was the 2012 incident.
Malaj, 2 submissions to make on this. Number 1, Malaj, PEL was a case where I had not even started building the transmission system. So therefore, there were no equities which had been created in my favor at that point of time. Number 1. Number 2, Malaj, ultimately, what is the consequence if the generation is not taking place? The consequence is that the transmission system is not being utilized and therefore the charges should not be levied. That is what their case is. Earlier also, Malaj.
If you accept that submission, Then what is the purpose of having a force majeure? Where will it apply then?
My lords, may I say this, my lords? So far as the transmission system is concerned, my lords, once the system is created,
Your clause has to have some application.
my lords have admitted the PEL appeal to examine this very clause, the force majeure clause and its applicability, my lords. My lords, may I just show only one sentence, my lords, one paragraph, my lords, of the earlier order, and then I will leave it at that. My lords will have the earlier order, which is at page, the relevant.
Force majeure condition at all.
Yeah, not force majeure at all.
Here the tribunal has looked into whether this was a force majeure condition and prima facie.
My lords, earlier also, my lords, there was a force majeure condition, namely, my lords, that the system was ready, but they were not in a position to commission the project. So therefore not utilize the system. Here also, my lords, the same situation exists, my lords.
The operation was stopped. Opposition by the villagers, they get some benefit. Why should we interfere in this?
In the earlier round, my lords, the tribunal says that if you are unable to.
Thank you, Mr. Srivastava. Item 16.
Arbitrator, my lord, the arbitration clause is at page 37.
The issue notice here.
We had served the other side.
Anybody here? We appoint an arbitrator.
Lordship, I'm seeking 1 week's time. It's a Singapore-based entity.
All right, we'll take it up next Monday.
Very good.
Please.
Take the issue notice, accepts notice, waive service, list on the joint request, list on Monday.
Great.
Give your appearance so that he'll have it.
Please, madam. Not here really a time barred claim has been allowed to be put into an amendment. And my lord, what has been done is that even without framing an issue on limitation, at least an issue on limitation could have been framed, or it could have been made clear that the amendment will relate back to the date of the application.
That the High Court has to deal with the issue of limitation, whether it has been raised or otherwise. So that can be raised at any stage.
My lord, it can't be, because if it is not put, then the law is, my lord, that it will always, the amendment will always relate back to the date of the plaint. So that's the limited point, my lord. And the judgment which has been quoted of my lords in that impugned order is not been quoted completely, because my lord does take into account that where a question of limitation is involved, where it's a disputed question, then it will relate back.
This is what an alternative prayer for refund of 2.75 crores.
Yes, my lord. 2.75, but the interest is there. I'm not on the alternative prayer. I'm on the interest on that. And I'm on the liquidated damages. But it's only on that part that limitation is a question which has to be framed.
You can ask them to frame the issue of limitation.
My lord may then clarify it in the order, because otherwise
you can always raise it, provide they've allowed
it can't be raised. The law is it can't be raised because the amendment itself relates back to the date of the claim.
It's an alternate claim.
If it is an alternative claim, my lord, and the alternative claim is barred by limitation, the point is very short. The court could have allowed the amendment, but also framed an issue on limitation and said that this issue will also be decided in the suit. And then I could have understood that that will go back and there'll be a trial on whether the claim is within limitation or outside limitation. But here that has not been done. Only the alternative prayer has been allowed of refund without seeing that the alternative prayer is actually relating back to 9 years back. But that's the only point on which I can only show from my lord's judgment. I can only show from one, if I can just show one page. If I can just show one page from the impugned order. All right.
19.
Please, my lords. Lords, we're impugning the judgment passed by the Honorable High Court.
Yes.
My lords, in this case, my lords, a recovery notice under section 79 has been issued to me, my lords, in pursuant to section 65. My lords, this case is completely covered by the case of Honorable High Court of Jharkhand, my lords, in the case of Mahadev. That travelled up to your lordships, my lords. But that case, my lords, was referred to the Lok Adalat. So, my lords, the point of law on which those cases were admitted, my lords, that still remains open, my lords. Now, since, my lords, the department was in appeal in those cases, my lords, those have not been decided. So this is a case, my lords, wherein a contrary thing has been.
But this is not an appeal by the department, this is by the assessee.
This is by the assessee. Yes. So, my lords, every judgment is in favor of the assessee. Barring this.
What is SLP 8370 of 2021? That is Union of India versus Mahadev Construction.
If I may hand over your lordships to the orders, my lords.
Eight three seven zero was disposed of.
Please, my lords. On the issue, my lord, that it is below the taxation limit, my lords.
Otherwise, the issue was the same as 83.
Please, my lords. Mahadev is the issue. Much obliged.
We'll hear them and
Lords, may I request a stay on the recovery proceeding?
say notice on stay also, serve them and come.
I am so much obliged. So much obliged. Much obliged.
Requesting for pass.
A subordinate, a junior judicial officer. It has been supported by the order sheets from the testimonies of the additional CJM and the district judge and your own admission ultimately.
My lord, kindly pass over, my lord. I'm just Mr. Patwalia is reading me.
All right, we'll pass it on.
Please.
May it please, my lords. Lords, the arbitrator admits, both under 14.1a and 14.1b, that the mandate has come to an end. The High Court notes this at page 14.
Serial number 21.
Sorry, 21.
21 will say place before bench of which one of us, Justice Manoj Mishra, is not a member.
Please, my lord.
My learned brother was
Yes,
part
my
of the full court
I
advice.
know, but my lord, I did not find my lord that I know, my lord.
All right, let my learned brother Pelj go before.
Yes.
All right. Tell Mr. Patwalia.
Deeply blessed.
Okay, why you know your thing.
Lords, the arbitrator admits that both under 14.1a and 14.1b, his mandate is come to an end. This, the High Court notes at page 14 as well.
Yes.
So the section 15 is but the normal course, my lords. I don't have any other revenue. And I say that I want to substitute arbitrator. High Court strangely, I think, has overlooked that part, which is noted by the arbitrator himself. If you just have page
Learned that says that the time limit in section 29A1 ended on 24th of October 2023.
Correct. But there was an extension of 6 months, which had been agreed between parties at the very inception. So rather than 1 year, it became 18 months at the inception, 18th April 22. That is in fact the stand that the respondent has also taken. As a result of which, within that at page 9, para 10, they note that fact. I'm sorry.
Substitute arbitrator could have been appointed.
So for the purposes of that is why the section 15 would follow. Now the court, I think, loses sight of the fact that at the outset, and that's what is captured.
18 months was agreed.
18 months was agreed. Now when 13 months had completed, I wrote a letter to the arbitrator saying, look, you've reserved orders on your section 16 application that you haven't delivered yet. So it looks unlikely that the under 14(1)(b) that you 14(1)(a) that you'll be able to complete in time. There seems to have been an undue delay. Arbitrator, and I thought that it was quite decent of the arbitrator to have noted at page 482. He says, in the above said backdrop, it also cannot be said that this tribunal failed to act without undue delay within the meaning of 14(1)(a) of the Act. This is what the arbitrator himself says. In any event, I do not wish to continue in this matter, and I hereby withdraw under 14(1)(b). So both under 14(1)(a) and 14(1)(b), his mandate has come to an end. At which point it has to be a substitute arbitrator.
You should notice in this.
I'm grateful.
Returnable, thus the permitted.
Yes.
Section 23.
Great.
My lords, the similar issue is pending for consideration before this honorable court, and the notice.
There's a delay of 219 days here, ma'am.
My lords, we are trust and we don't have like sufficient funds due to that, and
But that's all right. The court will decide that issue in the pending matter. Why should we keep on tagging matters? You can intervene in that matter.
non-local tribe. I'm for the non-local tribal, and I'm aggrieved by this order of Honorable High Court because it restricting my opportunities, my lords. And I was party before the honor.
Notice on delay and tag it with that Samajik Vikas Prabodhini. That is diary number 40524 of 2023. It has to be tagged with what?
SLP number 22,109 of 2023.
Notice on delay and tag. 24. Just notice on delay and tag, not on the delay.
But a very important question of law. I'll
Yes.
just give my lord 5 facts. Lord, your lordship did not write down, just my lord orally, how my lord things have developed. In 2010, I am university, I entered into a contract with the respondent for the purpose of Lord, I am the university. In 2010, I entered into a contract with the respondent to provide me with the content of my syllabus, which he provides. Thereafter, it is found that that was plagiarized. He has picked up from the internet. So, my lord, in 2014, I terminated the agreement. He admits that there is I have lifted it from somewhere, and he does not challenge termination at all. 2014 termination. Now, we commit a mistake. We move the arbitration, my lord, seeking a relief that please direct that we are not supposed to pay him anything. We did that, my lord. So that's a my lord, stupidity which we commit. He did not file a claim. He files a counter claim that I am required to be given 30% of the fee share. He succeeds in the counter claim and we pay him 30% of whatever fee share, my lord, we get. Lord, that happened in the year 2014. Matter rested there. In 2017, now he raises an issue that now I am challenging termination of the year 2014 and I am seeking damages for wrongful termination. Lord, section 11 is filed. We raised that objection. Court says you raise it before the arbitrator. But we raise it before the learned arbitrator saying that this is barred by res judicata and in any case by constructive res judicata. He could have in
his counterclaim, he only raised that issue of 30% share.
30% share. He did not challenge termination. He did not seek damages.
Yes.
So, my lord, we say that this is barred by res judicata and constructive res judicata. The learned arbitrator in one line dismisses that application. Now, the question is that dismissal, would it be an interim award amenable to section 34? Because your lordships in IFCO has said that if limitation is held to be a ground for not proceeding further, it's amenable to 34. And there are other judgments, my lord. Now, just, my lord, your lordships may have, my lord, the judgment in IFCO.
The High Court has held that you can raise this after the final award.
After 34 is not maintainable. That's what, my lord, the finding of the court is.
Yes.
And, my lord, compilation is on record. Please, my lord, have a look at
that. It's in the additional paper book?
Yes, my lord, there is an additional paper book compilation, my lord. Only one judgment. There are many on this point. My lord, this was mailed, my lord. I'm sorry, my lord. It is a compilation of judgments on behalf of petitioners. IFCO.
We have.
Next, detail.
This does not give judgments, but if it is there.
Copy, my lords, for immediate, 2018, volume 2, SC 534.
Your application which you filed before the arbitrator was under which provision?
Under 16.
16.2, right?
Yes, my lord. But that nomenclature would not decide the jurisdiction.
No. But your contention was that the claim was barred by?
Res judicata and constructive res judicata.
Is that a jurisdictional issue?
It is, my lord.
Jurisdictional issue.
It is a jurisdictional issue, my lord. That's what, my lord, there are judgments which says that one, if suppose the test is this, suppose it is accepted.
See, the test is this. Does the arbitral tribunal have jurisdiction to decide res judicata? If it has jurisdiction to decide res judicata, then, as Justice Datula once said, you can decide it rightly or wrongly.
Correct, my lord.
Right. Now, whether it is rightly or wrongly decided does not raise a jurisdictional issue.
My lord, for example,
something which is amenable to a challenge under 34, because res judicata is within jurisdiction. Just as a court can decide res judicata as part of its jurisdiction, so also an arbitral tribunal can decide the issue of res judicata as a matter within its jurisdiction. That decision of the arbitral tribunal, assuming it is wrong, is not a decision under 16.2.
Forget 16.2.
That's a decision of the tribunal.
I'm not on
then merge.
That is a second mistake which we have committed here. Nomenclature was wrong.
You can still challenge the award finally.
Only a minute. There are judgments. I would like, my lord, your lordships to be assisted with this judgment. My lord, your lordships may kindly see.
Lunch?
Your lordships need not come back after lunch. That's the request.
All right. But tell us, what is the judgment? See, res judicata, Mr. Solicitor.
I'm sorry, but I'm not saying for my matter, man.
Yes.
Generally,
res judicata is not a jurisdictional.
No, my lord, I'll my lord side judge.
Okay,
I want your lordships to be assisted with judgments. The reason is this. My lord, suppose I raise an issue of limitation, that this is barred by limitation. The arbitrator has a jurisdiction to decide the question of limitation. This honorable court, my lord, your lordships have said that if an issue of limitation is decided during arbitration, it is an interim award. It's like, my lord, that my lord, the suit, appeal under 96, dismissal on the preliminary ground is a decree, and therefore 96 applies, and therefore 34 applies. That is IFCO judgment in the Supreme Court, my lord. Kindly see, my lord, the judgment which I have, my lord, relied upon. There are other judgments also.
High Court hold here that the 34 itself was not maintainable.
Not maintainable, not on the marriage. And if your lordship, my lord, only sees one paragraph of one judgment, my lord, I have the compilation of judgment which I will assist your lordship with.
What?
My lord, kindly see.
Finding of an arbitrator.
My lord, there are.
The claim is not barred by res judicata amount to an interim award.
It is an interim award because if it would have been accepted, the arbitration would have been closed. My lord, that is the test. Suppose, my lord, I would have succeeded. What I am posing a question to myself would be the effect. Effect would be the arbitration proceedings would terminate. Well, therefore, limitation, well, this would need examination.
Mr. Nirav Thakkar is leading.
Please, Your Lordships, this ultimately, this is an application under section 16. This is an application under section 16 only, under 16(5).
But they exclude that from consideration for a moment, that they filed an application under 16, assuming that they refer to a wrong provision of law. There is a finding by the arbitrator that the claim is not barred by res judicata.
Please, Your Lordships.
If that application had been allowed, the proceeding of the arbitrator would stand closed.
My lords.
Right? So by
Correct.
not allowing the application, the proceedings are allowed to continue. Now,
My lords.
would that not therefore amount to an interim award within the meaning of the Act?
Therefore, Chintels India, if Your Lordships have 2021, volume 4 SCC, page 602.
21?
2021, volume 4 SCC, page 602.
Yes, upload karo.
Yes, Milos. This is what Milos, the Honorable High Court also considered, Milos, while dealing with the first appeal preferred by the university.
Let's see that.
Yes.
Well, I am relying upon IFCO.
Which para are you referring to in this?
Yes, please. From para 32 onwards.
Let's go to para 34.
After dealing with several judgments, Milos, the Honorable Supreme, my lords have held that the scheme of the Act is of minimal judicial intervention, and Milos, when the jurisdiction of the tribunal is decided by itself, saying that it has jurisdiction, the interference by a judicial authority, Milos, should be minimalized. And Milos, on para 32, while citing Milos, another judgment of Delhi High Court,
Para 32 may be read first.
Para 32?
I'll read para
It is
32.
very judgmental. The context, Your Lordship gets one. The context in which para 17 of so-and-so was made was a context in which an application under 34 would have to be returned to the court which had jurisdiction to decide section 34 application, dependent upon where the seat of the tribunal was located. Now, this is important. In this context, it was held that a mere preliminary step which did not lead to application being rejected finally cannot be characterized as an order which would result in application's fate being sealed once and for all.
Now, if Your Lordship consider section 16, in my humble submission, it is a code in itself. It takes care of two situations. Either the section 16 application will be allowed.
Let's just see section 16, what, and then we go to
Yes.
scope. Yes. Yes.
Yes, my lords. 16 says, the tribunal may rule on its own jurisdiction, including the ruling on any objections.
Decide on a plea referred to in subsection 2 or subsection 3, and where the arbitral tribunal takes a decision rejecting the plea. Now, here they rejected the plea.
No.
Yes.
They rejected your plea.
I'm not saying arbitral tribunal has no jurisdiction. I'm saying the claim is barred by rest. You have the jurisdiction.
No, the question is whether you can raise it at this stage. That's the point. Just see 5. Just a second. Just see 5. Just see section 16(5).
Yes,
the arbitral tribunal shall decide on a plea referred to in subsection 2 or subsection 3, and where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceedings and make an arbitral award. Now, they rejected your plea of res judicata, in which case they have to continue with the arbitral proceeding and make the award. That award is amenable under 34(3).
That's your lordship.
If they had, one second, if they had accepted your plea that it was barred by constructive res judicata, that would have brought an end to the proceedings.
Please, Your
That was
Lordship.
amenable to 34.
My lords, that is the law. That is what Mr. Chintan suggests.
Lord, can I complete, my lord? If you don't, your lordship, my lord,
37 accepting the plea referred.
Lord, can I have not cited the judgment which I rely upon.
Only, my lord, if the plea is
Lord,
accepted, then
can
an
I
appeal
request?
lies.
Lord, have it on Friday. I'll circulate the list of
No,
judgments.
but just see 37(2)(a).
My lord, 37(2)(a) will have.
Or shall also lie to a court from an order of the arbitral tribunal, A, accepting the plea referred to in subsection 2 or subsection 3 of section 16. So where the
I'm
plea
not on
accepted,
16, my lord. I'm not on 16.
your application was under 16.
Lord, wrong mention of a
You made
provision.
an application under 16.
If this, I'm sorry, my lords, I'm sorry to
Allow me
interrupt, my
to
lords.
place judgments. Allow me to place judgments. Lord, this is a question.
Ultimately, it will, you can.
No, Lord, allow
it's
me to
left
place
open.
judgments only. I have the
No, no,
compilation. We'll
may I
circulate.
just add one?
No, not Lord, after lunch. Have it on Friday.
No, you come back after lunch.
Lord,
Just say.
after,
Asta is here, she'll argue.
Lord, I have a part.
Your junior is there, she'll
No,
argue.
Lord, kindly have it on Friday.
No, we'll do it. Come.
Check.
Can I get 5 minutes in that intercountry adoption matter?
Yes, definitely. Take it up.
8 minutes.
May it please, Your Lordship.
Yes,
Lordships may give me some time, my Lord, to assist your Lordships on this.
Yeah.
Lord, because this will, my Lord, go to the root of the matter. And there are several issues, my Lord, which are arising in this case. My Lord, please have a look at 16. Lord, first of all, I did not cite 16. Lord, I need not cite the judgments which takes the view that a mere wrong citing of a provision will not deprive the tribunal of its jurisdiction if otherwise it has. Lord, 16, please read, my Lord, and what, my Lord?
Except that but for the fact that you raised it as a jurisdictional question, the tribunal would not have rendered an award upfront, an order upfront. Normally, the issue of constructive res judicata would have been dealt with in the final award, as in a suit. As in a suit, the trial judge will deal with a host of issues, limitation, res judicata, issue estoppel, merits. So the reason why the arbitrator dealt with it upfront was because you raised it as a jurisdictional issue under section 16.
My Lord, if your Lordships are assisted with the judgment substantially directly on the point, where...
What do they say?
Yes, my Lord. I'll just say and thereafter take your Lordships to the scheme of two provisions and the judgment. It says that jurisdiction of the tribunal under section 16 is different in the sense, what can be the jurisdictional ground that the contract under which the arbitration clause is contained is unenforceable contract, and therefore you are not a validly constituted tribunal. Or the contract does not contain any arbitration clause, and therefore I am questioning your jurisdiction to be the arbitrator itself. Or the contract does provide for an arbitration clause, But there is a different mechanism provided for the purpose of appointment.
But those cases
On-
stand on a, I'll tell you what, those cases stand on a different footing for the reason that if there's an absence of an arbitration agreement, the tribunal cannot decide at all. Therefore, the question about the existence or non-existence of an arbitration clause is an issue of jurisdiction. Now, res judicata is an issue which the tribunal has the authority to decide. Therefore, it is not a jurisdictional question.
Therefore, not 16. That's my contention.
Right. If it's not 16,
yes,
then there is no arbitral award right now.
No, kindly, my lord. Therefore, my lord, kindly see the judgment.
Then
The lordship have a direct judgment on.
Let's see that. You may be
Yes.
right. Let's
Lord,
see that.
give the citation, compilation. My lord, compilation is handed over, my lord. My lord, please have a look at. My lord, please have a look at judgment number 3, IFCO, my lord, 2018 to SCC 534. Kindly come to, my lord, compilation page number 32. Lord, kindly, my lord, give me, my lord, for 5 to 10 minutes to read relevant paragraphs, my lord. Lord, would your lordships come to page para 6? Well, it's an important question. It's not a question whether I succeed in this matter or lose in this matter. My lord, it's an important question. Please have a look at, my lord, para 6. May I read, my lord, para? Your lordships are possibly on some other.
Para 6.
Page 32, para 6. Because the head note, my lord, possibly does not convey the real crux. 6. The point at issue is a narrow one. Whether an award on the issue of limitation can first be said to be an interim award, and second, as to whether a decision on a point of limitation would go to jurisdiction and therefore be covered by section 16 of the Act. Lord, kindly now, my lord, come to page, my lord, 5. Para 9. To complete the scheme of the Act, section 32(1) is also material. This section goes on to state that the arbitral proceedings would be terminated only by the final arbitral award as opposed to an interim award, thus making it clear that there can be one or more interim awards prior to final award, which conclusively determine some of the issues between the parties, culminating in a final award which ultimately decides remaining issues. My lord, please come to, my lord, page 35, running page 35 of the running page 35, internal page 545. Your lordships have, my lord? I'm sorry, my lord, your lordships would like me to read anything else?
Paragraph?
Lord, page 35, para 14. McDermott is cited. I'm not reading McDermott, but please see at the foot. After citing, my lord, the Honorable this court says, the aforesaid judgment makes it clear that an interim award or partial award is a final award on matters covered therein made at an interim stage of arbitral proceedings. Now 15. Next page, my lords.
Yes.
Tested in light, your lordship gets, my lord, 15. Now, 15 to 19 are very crucial for assisting your lordships on this. Tested in light of the statutory provisions and the case law cited above, it is clear that as the learned arbitrator has disposed of one matter between the parties, that is, on the issue of limitation finally, the award dated so-and-so is an interim award within the meaning of section 2(1)(c) of the Act, and being subsumed within the expression arbitral award, could therefore have been challenged under section 34 of the Act. However, Sri so-and-so has argued before us that award dated so-and-so being a ruling on the arbitral tribunal's jurisdiction would fall within section 16 of the Act, and in as much as the decision taken on the point of limitation was rejected. The drill of section 16 must be followed, in which case all other issues have to be decided first, and it is only after such issues are decided that such an award can be challenged under section 34 of the Act. Section 16 of the Act lays down what in arbitration law is stated to be competence principle, that is, what an arbitral tribunal may rule on its own jurisdiction. At one time, The law was that the arbitrator, being a creature of the contract, could not rule on the existence or validity of the arbitration clause contained in the contract. This, however, gave way to competence principle, which was adopted by Unicitral Model Law. Article 16 of the Unicitral Model Law, on which Section 60 of the Act is based, reads as follows. My lord, I'll skip that. Please come to 18, para 18, my lords. I'm sorry, my lord. Am I, my lord,
Yes,
doing
para 18.
para 18? It may be noticed that Section 16, 1 to 4 are based on Article 16 of Unicitral Model Law. The competence principles deal with arbitral tribunals' jurisdiction in the narrow sense of ruling on objections with respect to the existence or validity of the arbitration agreement. What is important to notice in the language of Section 16(1) is the fact that the arbitral tribunal may rule on its own jurisdiction, which makes it clear that it refers to whether the arbitral tribunal may embark upon an inquiry into the issues raised by the parties to the dispute. Here again, the English Arbitration Act throws some light on the problem before us. Section 30 and 31 of the said Act reads as under. Please see, my lord, Section 30 of English Arbitration Act. Competence of tribunal to rule on its own jurisdiction. Unless otherwise agreed by the parties, the arbitral tribunal may rule on its own substantive jurisdiction, that is, as to whether there is a valid arbitration agreement, whether the tribunal is properly constituted, and whether what matters have been submitted to arbitration in accordance with the arbitration agreement. Any such ruling may be challenged by any available arbitral process or appeal or review or in accordance with provisions of this part. 31 may perhaps not be assisting your lordship. Kindly turn the page over, para 20. This section makes it clear that competence principle, which is also followed by the English Arbitration Act, is that the jurisdiction mentioned in Section 16, well, that is our section. I'm sorry, Manoj.
Yes.
Manoj, I'm on page 38, para 20, Manoj.
Para 20.
Para 20, Manoj.
Yes.
My Lord Justice Mishra and Justice Padiwala as para 20. But my Lord, the Chief Justice was not there. But I'll read it again. This section makes it clear that competence principle, which is also followed by the English Arbitration Act, is that the jurisdiction mentioned in Section 16, that is our 16, has a reference to three things. One, as to whether there is the existence of a valid arbitration agreement. Two, whether the arbitral tribunal is properly constituted. And three, matters submitted to arbitration should be in accordance with the arbitration agreement. That jurisdiction is a coat of many colors, and that the said word displays a certain color depending upon, I'm sorry. So there are other judgments also. So therefore, only thing I was saying that this is a matter which deserves your lordship's consideration. There are further paragraphs as well, Manoj. Kindly see, my lord, that there are certain more paragraphs, my lord, which will assist the court. But kindly see, my lord, the drill we will have to go through. He admits that there was plagiarism. He takes the money which was due to him. He does not challenge termination. And after limitation, he challenges termination.
The court order.
Close. Entry 58, declaration that the termination was unlawful.
This side, let's see what they have to say.
Would your lordships not
Yes.
like to consider this? Because there are other judgments I would like to assist your lordship with.
What
And,
do they say?
Lord, on the same line, that 16 is jurisdiction means competence. On marriage, my lord, in this very judgment.
But you raised the section 16 objection. You raised an objection under section.
Lord, I raised order 7 rule 11 objection. The wrong mentioning of the title was 16. But my objection was that this is barred by order 7 rule 11 because of res judicata and constructive res judicata. When they filed a counter claim in the first round, they could have said that declare that the termination is wrong.
Okay, let's hear Mr. Thakur. Mr. Thakur,
Yes.
what do you say?
Yes, because for 5 years, they have been saying that we have been contesting section 16 application. Now, because before the honorable tribunal, if section 16 application is not what they meant to file, then in my humble submission, there is no provision under which such an application can be entertained. There is no application, the scheme of the act does not envisage interim applications where some orders are sought which are made appealable under section 37. The only appealable orders under 37 are if an application is made under section 16, because either the application under section 16 will be allowed or it will be dismissed. If their application under section 16 is allowed, an appeal is provided to me under section 37 2. If your lordships will just have section 16 for a moment. This is the only application which can be entertained by the learned arbitral tribunal, which goes to decide whether the proceedings are to proceed further or not. Section 16 says competence of an arbitral tribunal to rule on its own jurisdiction. Subsection 2, a plea that the arbitral tribunal does not have jurisdiction shall be raised not later than the submission of the statement of defense. However, a party shall not be precluded from raising such a plea merely because that he has appointed or participated in the appointment of an arbitrator. 3, a plea that the arbitral tribunal is exceeding the scope of its authority shall be raised as soon as the matter alleged to be beyond the scope of its authority is raised during the arbitral proceedings. Subsection 4, the arbitral tribunal may, in either cases referred to in subsection 2 or 3, admit a later plea if it considers the delay justified. Now, if your lordships have 5, the arbitral tribunal shall decide on a plea referred to in subsection 2 or subsection 3, and where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceedings and make an arbitral award. Now, my lords, why?
Yes.
Yes, now why I'm saying section 16 is a complete code in itself is that, when a section 16 application is made, if it is rejected, then subsection 5 mandate kicks in, which says the arbitral tribunal shall decide on the plea referred to in subsection 2 or 3, where the arbitral tribunal takes a decision rejecting the plea, continue with the arbitral proceedings and make an arbitral award, and such arbitral award under subsection 6. A party aggrieved by such an arbitral award may make an application for setting aside such an arbitral award in accordance with section 34. So if their application is dismissed, the arbitral proceeding has to proceed further, and whatever ultimate arbitral award is passed by the tribunal, it has to be challenged under 34. Now, the other scenario would be if their application is allowed. If their application is allowed, my lord, may kindly refer to section 37. Section 37 refers to appealable orders. An appeal shall lie. May I read, lords?
Not only one thing.
Let me just
If
complete
my
reading,
plea
sir.
is accepted and which is appealable, that means I can move an application.
To set aside an arbitral award.
An appeal.
Yes.
An appeal shall lie from the following orders and from no others to the court authorized by law to hear appeals from original decrees of the court passing the order, namely so and so, so and so, so and so. Now, your lordship says subsection 2. An appeal shall also lie to a court from an order granting of the arbitral tribunal A, accepting the plea referred to in subsection 2 or subsection 3 of section 16 and granting a refusal. Now, if it is accepted, if that application is accepted, then the arbitral proceeding comes to
under 34. Then you go under section 37(2).
37(2)(a) is the substantive portion of the statute which grants me the power to prefer an appeal.
So if the arbitrator holds that they have no jurisdiction, then the remedy is a substantive appeal under 37(2)(a).
If their application is allowed, then I'll have to move under 37(a), but the grounds will be limited to section 34 only.
Right.
But because a statutory right is given under 37(2)(a).
Appealable orders, not restricted by 34.
Now, today their application is rejected.
2(a) is a direct appeal from an order of the tribunal.
Correct, my lord,
So
but
where the tribunal accepts a plea under section 16.
That I am wrongly constituted or I am not.
No, that is not the only ground. That is not the only ground.
So you filed a petition under 34.
Yes, which was
34 was rejected.
On the ground that it's not maintainable.
Right. Then you went in 37.
Yes.
37 has been rejected.
Yes.
But how would 34 lie against that?
Now, one more aspect. Read
the judgment further. Kindly read the judgment further.
May I just complete my side of the argument, sir? There's only one aspect which my learned friend says. My learned friend says that it was not an application under section 16. First of all, at the outset, this comes for the first time before this.
What is the meaning of 16?
Secondly,
this was an application under section 16.
It was an application under section 16. It was considered by the courts as such, and it was argued as such. It was dealt as such, and now today it is said that it is not
194.
Not, Mr. Solicitor. If it was not an application under section 16, how is it maintainable?
194.
Exactly. There is no provision under which it can be filed.
My lord, kindly see, my lord, this is
Under
something
what provision of the
which
arbitration?
deters, my lord, arbitration as a, your lordships have seen the, my lord, finding.
No, but under what provision of the law?
Lord, under, that was
the
my
act.
question, under which provision of law you are going for second arbitration?
No, no. Under what provision of the law
What,
did you, one second,
Kindly have a look.
the appointment of the arbitrator attained
194.
finality, Mr. Solicitor?
Yes, my lords,
The appointment of the arbitrator attained finality. Appointment of the arbitrator under 11.
Yes,
Yes,
attained
yes.
finality.
yes, my lord.
it traveled up to the Supreme Court.
You were challenging the jurisdiction of the arbitrator on the grounds of res judicata. Under what
No,
provision?
not ground. I'm not challenging appointment of arbitrator at all.
Right. But
That's
you are
the-
challenging now, you are saying that this claim is barred by res judicata.
You are rightly appointed.
Right.
But
that
you
this claim,
decide.
this claim is barred by res judicata.
Yes, my lord.
Under what provision did you get the arbitrator?
194, page 194. Kindly have a look at
No, under what provision of the statute?
Section 11 CPC read with, my lord, order 7, rule 1. It's not barred.
No, but arbitrators are not bound by the civil procedure code.
They are not bound. Doesn't mean, my lord, they cannot resort to that.
No, but
not.
therefore,
No, I
it had
didn't lose on that.
ordinarily, the arbitrator would say that I'll decide this when I deliver my final award.
But that's not what they have said.
You got him to rule on jurisdiction under section 16. Therefore, he ruled out in upfront.
No, my lord.
But for the fact, one second.
Lord,
for the fact, Mr. Solicitor, but
Lord,
for the
kindly
fact.
allow me to read, my lord, fully.
No, all right. Page
38. My lord, we will have to, my lord.
All right, where is the order?
Only
Where is the order on your
only a minute,
application?
my lord. We will have to understand 16 is, I am saying that you, Mr. Arbitrator, are wrongly appointed, not appointed in accordance with arbitration clause, or there is no arbitration clause. That is 16. No provision, my lord, prohibits me to point out that your jurisdiction is being abused. You invoke CPC. CPC doesn't bind you, but that does not mean that CPC cannot be resorted to. My lord, please have a look at, my lord, para 22, para 21, my lord, para 21 at page 38. This is precisely the distinction drawn in this judgment. Am I with your lordship?
Yes.
38, para 21. The jurisdiction is a coat of many colors, and the said word displays a certain color depending on the context in which it is mentioned is well settled. In the classic sense, in official trustee versus so-and-so, my lord, they have given, I am not reading, my lord, that. Please see 22. A constitution bench of this court in so-and-so versus so-and-so made a distinction between an erroneous decision on limitation being an error of law, which is within the jurisdiction of the court, and a decision where the court acts without jurisdiction in the following terms. I'm not saying that you don't have the jurisdiction. They have decided, exercise the jurisdiction wrongly. That's my case. The first point raised by Mr. So-and-so for the appellant is that decree number so-and-so obtained by so-and-so and his brother in the suit for the hypothecation bond executed by so-and-so in favor of so-and-so was a nullity because the suit was barred by time. In assuming that the suit was barred by time, it is difficult to appreciate the contention of the learned counsel that the decree can be treated as a nullity and ignored in the subsequent litigation. If the suit was barred by time and yet the court decreed it, the court would be committing an illegality, and therefore the aggrieved party would be entitled to have the decree set aside. But it is well settled that a court having jurisdiction over the subject matter of the suit and over the parties thereto, though bound to decide right, may decide wrong, and that even though it decided wrong, it would not be doing something which had no jurisdiction to do.
May I just point out one more thing?
Only one. Mr. Thakkar, there is some sequence. I put it as mildly as possible.
You can scold me, sir. I learned a lot from you, sir.
What is this, Exhibit 7? जवाब नहीं मारते क्या आप? There are other judgments on this, my lord. But this is not a matter where your lordships may not like to consider it. Otherwise, my lord, this is a serious deterrent. My lord, anybody can file anything, and the party at the receiving end will have no remedy to point out that your time is wasted, my time is wasted, and our money is wasted.
Your claim is under section 16.
My lord, if that word, my lord, troubles the court, I can't help it.
Just see annexure P8.
194.
Page 194. You say section 16.
My lord, do I need, let me cite a judgment, my lord. There is a judgment which says,
you're right. It's
wrong
not section-
provision, my lord, would not.
You're right. But that applies to what? That applies where a statutory authority has passed an order and that order invokes a wrong provision of law. It has no application in a situation under an arbitration proceeding.
I have invoked.
One party raises a dispute under section 16 and says, no, I wrongly referred to section 16. Then the question is, if you wrongly refer to section 16, why would the arbitrator decide it as an issue upfront? You would say, I'll decide it at the end. I'll decide it as one among all the other issues.
Arbitrator does not say that, my lord.
No, but he decided it upfront for the reason that you raised it under section 16. Isn't it?
My lord, my lord, I don't think, my lord, there can be any answer except saying that a wrong mention of a provision would not, my lord, would not shut out a good case.
Mr. Solicitor, it was not a wrong mention for the reason that but for the fact that you referred to section 16,
this would be
you wouldn't have rendered a finding upfront. You would have
say one thing.
dealt with it like all other issues.
I can say one thing. This, my lord, by the way in which it is dealt with, is and will be a serious deterrent to arbitration as a alternative mode of dispute resolution. I leave it at that. There are some other paragraphs also I would like to see, my lord. I would like to read. But, my lord, I leave it to your lordships. If 16 is to be, my lord, I can't overcome 16, then, my lord, there is nothing. This needs, my lord, detailed consideration. Would your lordship see page 39, bottom 23? I'm sorry, my lord, I'm dragging, my lord, but, my lord, otherwise, my lord, this kind of my lord, abuse of arbitral proceedings, my lord, would continue unabated. Please see 23. Your lordship has, my lord,
Yes.
page 39, my lord.
39.
Running page 39,
Yes.
para 23. It is in this sense of the term that jurisdiction has been used in section 16 of the Act. Indeed, in NTPC, a division bench of this court, after setting out section 16 and 37, held, now the only question that remains to be decided in the present case is whether, against the order of partial award, an appeal is maintainable directly under section 37 of the Act or not. We have considered the submissions of the learned counsel for the appellant, and after going through the counterclaim and the partial award, we are of the opinion that no question of jurisdiction arises in the matter. I'm sorry. Lord, please bear one worry in mind. In stretching this, my lord, but my lord, these detailed discussion, my lord, deserves issuance of notice, my lord, and consideration.
We'll close it for judgment. We'll settle the law on this. You file brief notes of written submissions of 3 pages, and we'll
Lord, would
both
your
sides.
lordships consider, my lord,
Yes.
settling the law without being assisted by the judgments, my lord?
You can
Instead,
no,
don't cite
you cite those judgments.
But instead, I am requesting, don't settle the law or allow us to assist fully. I'll say why, my lord, why I say this. My lord, no, my lord, there is something.
SLP dismissal. We are very clear now.
Only a
We thought we'll settle the law and
Only a minute. Only a minute. My lord, what is my worry? And please, my lord, kindly share that worry with me.
I'll tell you what our worry is. If we accept your submission, at every stage of the arbitral proceeding, people will file 34 and completely defeat arbitration. So that's the danger. That is what, every stage of arbitral proceeding against a finding by the arbiter, they will invite a finding, and then look what happens here. You file an application treating it under section 16. If you had not filed it under 16, the arbitrator would have said, I'll deal with it at the end. You get an order under section 16 objection. She says that this is not barred by res judicata, in which case 16.5 says, you will then proceed with the matter and then deliver the final award. 16.5 distinguishes between decision and award. So the decision on the objection under 16.2 is not treated as an award by the section 16.
Can I share my concern? Forget the matter. I've closed the file.
That's the problem. This will defeat arbitration if we accept.
I'll close the file, my lord.
Maybe this case, he probably took a little bit of a chance. Fair enough, but we can't decide the law on the basis of one case like that.
Can I, my lord, now share, my lord, after closing the file? But suppose he files a third claim. Section 11 court would say that raise this issue that there are already one arbitration concluded and one going on before the arbitral tribunal. I'll go before arbitral tribunal would say, I'll decide finally. Ultimately, I'll take a call as an university that henceforth in my contract, arbitration clause will not be there.
That's all right. The government has also said no arbitration above 10 crores.
I'm going to argue that tomorrow. I'll not, my lord, preempt that argument, my lord. I'm not preempting that argument. But there are several issues, my lord, why it is not succeeding.
All right, we'll, I think.
Lord, your lord, it's questions of law.
No, now we are just dismissing it.
No, questions of law in this matter. No, in this matter, I'll have to argue res judicata, etc., my lord, at the final stage.
No. Res judicata, now after the award is declared, you can challenge it on under 34.
No. Impugned judgment keeps it open.
Then why do we have to say that? Then the impugned judgment.
You don't think, my lord, it's that bad a judgment? Your lordship would
not even. The impugned judgment has kept it open, we keep it open. Then we are simply not interfering with the matter. That's all.
My lord, would your lordship say in view of that para, my lord, that your lordship said?
No.
Well, otherwise, I'll be.
But we are affirming the judgment of the High Court.
I leave it to your lord.
Yes. 25.
I will not challenge that. But subsequently, my lords, 23, 24.
When the matter came up on 23rd April, you made a submission that prayer 2 would not be prayer.
No, my lords. In fact, I said prior to, my lords, 10th of November 21, because I had challenged 20, 21, etc. So I filed an application. I have never made that statement. If your lordships have the order first, if your lordships have page 372, this is the order, my lord. And in paragraph 2 at page 373, we find that in prayer clause 2, applicant has challenged 156 tender notices. These tender notices are very old notices and have already been acted upon. And I'll show not all of them are old. There are somewhat 24 as well. In view of this, learned counsel for the applicant has fairly submitted that she is not pressing the prayer clause number 2. Now, my lords, I move an application immediately, 15 days later. And then, my lords, that's the next page. And I specifically, my lords, submit that kindly see paragraph 4, my lord.
Yes.
It is submitted that what was considered by the counsel for the applicant during the hearing was to give up the challenges to 44 notices prior to 10th of November. And I said this on affidavit, my lord. Now kindly see over the page, my lord. Now old notices, my lords, I am not going to challenge it. So that people have acted upon. But in cases where the mining operations are still to begin, let's kindly see page 377. Now, my lord, there are e-auctions from 20.
Mr. Kamath, the court is really the final word on what happened and transpired in court.
Yes, my lord.
They record a statement of counsel. When the matter was taken up on 23rd April,
yes,
it was brought to the notice of the counsel for the applicant that the applicant had challenged 156 old tender notices, which were already acted upon. And the counsel for the applicant had fairly submitted that she was not pressing prayer clause to challenging those notices.
Yes, my lord.
This is the end of the matter.
Lord, but I have filed an application. I've said.
Why should we disbelieve what the court has recorded?
But kindly see, my lords, there are, my lord, the finding that these are old notices, my lord, are wrong. My lords, 2024 notices, my lord. I bow down. I bow down. What I'm only saying, my lord, I'm not pressing as far as old notices are concerned. Your lordships have taken the view, my lord, that as far as wherever mining operations have not begun, please have a look at that order, my lord, which your lordships passed at page 310. Where mining operations have not yet begun, I am not challenging the award of tender to anybody. Lord, let him, my lords, get the tender. I am only saying, my lord, where the tender has been awarded, mining operations have not started. Lord, DSR has to be in place. Replenishment studies have to be done. Please have a look at that order, my lord.
Once you had given up, what was recorded by the court was a correct.
Lord, I have said that was wrongly recorded, my lord.
Will not go. Thank you.
Very grateful.
26. Yes, Mr.
My lord, in 26, the award is assailed by the 34 and.
Is there any delay in 26?
Yes, there is some delay, but the parties are actually based out of Canada, and the mother of one of the directors was ill for 2 months. There's a delay of 100.
Substantial delay.
There's a delay of 144 days. I have to say, my lords, because they were in Canada, and this is a very lengthy SLP.
It's on limitation.
No, my lords, would my lord just consider, we are being relegated to a third round of arbitration if my lords dismiss this. We are a company where the fraud is admitted. In fact, the arbitral tribunal acknowledges that there is fraud by the respondent. That finding is in fact upheld in the division bench. My lord, but despite all of this, we are being relegated to a third round of arbitration because of a 34 which says that there is no evidence.
You should have come earlier. It's a Canadian company. I mean, you are a commercial entity. 140 days delay, why should we condone in commercial matter?
My lord, in a situation like this, may I beyond saying the reasons for that delay, my lords, I can't press further on the delay because we are a Canadian company, and because of that, there was some back and forth. And the director, in fact, the mother was unwell. We've said that. Because of that, we could not get confirmation from the Canadian company. But, my lord, on merit, this is a very fit case, my lord, if I may. I have a lot to say on merit, my lord.
Just on delay. There's a delay of 140.
My lord, it's just 4 months, my lord. It's not that considerable, my lord.
Filing the
it's the third round of arbitration which we are going to. And in fact, from Allahabad, please look at their conduct as well.
Having considered the shown, there's an absence of a sufficient explanation for delay.
My lord, our explanation is twofold. One is that it's an extremely long SLP, my lord, and therefore the preparation also took some time. My lord, 4 months is not. My lords have condoned. May I just address
commercial matters? Not like some employee's pension or something where we condone, but commercial matters.
No, but my lord, something like this
is
us, my lord, and it's acknowledged in the arbitral tribunal, and the tribunal, in fact, is a very well-reasoned award.
Vested rights. Thank you. Yes. Thank you, Mr. Naidu. 27 and 15.
7 is an appeal by the COC.
59 by me, 59 I am the SRA.
Which is the group of lenders. In short, what has happened is this. R4, my lord, filed a plan. Before the plan could be approved, my lord, finally, an RBI circular came, which questioned, my lord, the wherewithal of R4 in terms of, my lord, standing. The plan had a clause, my lord, that he can have a nominee. Nominee is R3, which is a part owner of R4. It's not an outsider, my lord. He's a 19 or 17% of R4. So, my lord, matter went to NCLT saying that substitute R4 by R3, but the plan remains the same, commas and dots, my lord, will remain the same. My lord, NCLT said, let the COC, which is me, examine the issue of substitution and examine again whether the plan is appropriate or not. Once again, because R3 has come. I again examined, my lord, R3, it's an identical plan, and I approve it. When I approve it, NCLT, my lord, accepts my approval and the plan is approved. My lord, a person who is not directly concerned files an appeal. Why I say that? My lord, the corporate debtor had some land like an SEZ. That was given on lease to, my lord, one Reliance company. This gentleman who is the objector, my lord, is in control of that land through Reliance, and Reliance, that company is also, my lord, in IBC. So he is interested in, my lord, retaining possession. So he filed his own plan. His plan was rejected by me. He wanted to object to the new plan. NCLT said, if you want to object, you go to COC and say something. He keeps quiet. Once, my lord, NCLT approves the substitution of R4 by R3 and approves, my lord, the plan on merits, he then comes and files an appeal. I am saying it on the ground, my lord, of agreed person. According to me, he is not agreed. Now, the NCLAT, at the instance of that person, says that there is no, my lord, clause for substitution or modification. It's not really substitution, because when somebody else comes in and propounds the same plan, who was a part owner of R4 and who is a nominee and a part owner of R4, his plan is examined.
Did the resolution plan, which was accepted originally, provide for a nominee of
Yes,
R4?
it provides for a nominee, and this man is a part owner cum nominee of R4. He is not, my lord, a subterfuge, my lord, who coming like a sublettee. And there, what is the purpose? Now, my lord, see one more thing. This process started in 2020. We are in 24. After 4 years, you set aside when the COC group of lenders, my lord, have accepted the plan and implemented the plan substantially. We have received 25 crores. We as lenders have appropriated the money. We have got shares issued in view of the debt. So many things have happened.
Who does the COC consist of in this?
Of these lenders, my lord, who have got the money. I am COC means I am the group of lenders. I have approved the plan. I have approved the substitution. The substitution is not according to, my lord, not contrary to law. The substitution by the nominee, just keeping the same plan, my lord, together.
The tribunal says now issue a fresh Form J and
Go back, my lord, step A. To say do it in 90 days, my lord, is with respect, it takes 4 years. From 2020, we have gone on to 24 in the first round.
Dr. Singhi, who are you appearing?
He is for the successful R3 now.
59 and add 5 sentences. This swan mullets unfortunately becomes a crow because he files against and unconditionally withdraws his application, recording that I'm withdrawing unconditionally. That is his IA 68 at page 170 before the NCLT.
After
withdrawal, he resiles his withdrawal, goes to NCLT and gets an order of reversal against me.
And his own plan
he also filed a plan, and then he withdraws from his plan.
His plan was rejected.
He challenged it.
Into 2021. His plan was rejected, my lord. He is now an obstructionist.
Not only with
somebody else's plan.
His plan away. His plan rejected. He objects to my plan. Then he withdraws his objection to my plan. And then gets this order reversed, follows an appeal. One more thing, very interesting.
Mr. Kirpal is appearing for the other side or is appearing with you?
One more sentence.
I think Mr. Kirpal is for the other side.
Well, one sentence. The plan is fully implemented. It's been
Mr.
2 years
Kirpal,
now.
what do you have to say?
Well, it's not correct. The plan provides for a nominee. In fact, that is discussed in paragraph 30, that there is no provision for a nominee. So what they're doing now is bringing a new person to come in and substitute. Because today this is permitted. Tomorrow anyone can come. All that the NCLAT has said is you have to start the process again, because that is the law. You can't start now changing parties by piercing corporate veils and say, okay, not me, someone else will come. My lord will see this nominee discussion at paragraph 30, page 24, paragraph 24. And the findings at page 26. Paragraph 32. When we look at the clauses of resolution plan relied on counsel, it said regarding infusion equity, which can be infused by a resolution applicant directly or indirectly through subsidiary. The clause infusion of equity cannot be read to mean that SRA can nominate as SRA. You can't have a substitution. You can get the
Nomination is provided in the plan.
This
Your
is
Lordship
not
has seen that.
exactly the finding that they
Filing
cannot
because it's
have a
confidential.
nominee.
114.
Give this page.
So
Take out
this
this.
is so the point is,
Give copies, give copies.
Take out this page and give it here.
The substitution was before the plan was approved by the NCLT.
Yes.
Because of the new RBI circular.
Because of the RBI circular creating a doubt, my lord, on the strength of R4.
because what happens in this case is, in terms of facts and dates and timelines.
Somebody else related to them can file, but we don't want ARCs to do plan filing. That was a new circular. It happened midstream. And they were then openly, everything is openly
At
done.
that stage, your the plan approval had not been decided upon.
Before that.
Plan itself is ready for this.
Because the plan has been approved by the CUs, then the circular comes.
Yeah, just the copy.
That is exactly, so they should have, ideally at that stage is when in 2021 that a fresh notice should have been invited. Now, just because you force the COC to carry on and examine your plans.
Let's see the clause, one second.
Kindly see the clause, my lord. Infusion of equity, subclause 3.
All three.
A need-based amount of so much shall be infused by the RA directly or indirectly through subsidiary, special purpose vehicle, limited liable partnerships, nominee of the resolution applicant into the company from its own funds. It's there. And below, at the end of the day, he's not a stranger.
The point is, as Mr. Kripal says, can a mere provision for a nominee mean that anybody else can be substituted?
No, so, my lord.
Changed.
Otherwise, what happens is, look,
but the plan
is normally somebody goes for the resolution plan approval says, this is my track record.
Yes.
This is my capability to furnish investment, infuse funds.
Right.
Now, if that person is simply substituted by someone.
Correct. So, my lord, after the substitution, NCLT said, examine.
Identical.
What my lord, the Chief Justice is saying, NCLT said, we will not approve. You show to my lord the COC that the R3 is now a fit and proper person who can propound this plan as his own.
COC thereafter.
Yes.
ratified.
Yes. Yes. So it's not, my lord, just a substitution. It's not like order 1 rule 10, you remove somebody and somebody.
That is not the point. The point
He was wise enough to say,
examine
how
other
did he
people.
go on like this, my lord? And what is his, my lord, and what is his
We'll consider it, Mr. Kripal.
role? My lord, he has no role.
If you notice, we file a short return and we'll dispose it.
It's a very short
It's
question.
a very small question.
We'll do
Because here, it's not as if the resolution plan approved, the resolution plan, sorry, the successful resolution proponent, he did not unilaterally substitute somebody.
Correct.
This is where the COC itself has.
And COC has examined, my lord, the new person.
I'll file a reply. That's not correct.
And the fact that he's not a stranger.
Status quo as to third-party bidders now.
Now it will start again, my lord. The High Court, the tribunal has
4 years now, there'll be a.
again you start. 4 years.
What we do is.
Let the process carry on and no final decision can be taken because otherwise, supposing the appeal is dismissed, in law, everything carry on.
People will
Status quo must be maintained as of.
If you notice, returnable on, Mr. Saurabh Kripal made to make answer. The status quo shall be maintained. No fresh resolution plans shall be considered.
I'll take notice for respond number 2, Manoj.
Minutes 59 is also a connected matter. Minutes 59 is also a connected matter.
Both.
27 and 59.
Both. 59 SRA. Also great.
Please, my lord. Here, my lord, the petition is at serial number 16. And
why have you come here? You can go to the Kerala High Court.
Lordship, kindly see, subsequently there is a notification and the chairperson is the Honorable Judge of this Honorable Court. That's the problem. I won't get a stay.
Sorry?
Subsequently, there is a notification for 3 appointments. I want a stay of that.
Why? Why should we do that? We not do anything of the sort. And if you want, why should we entertain a petition under Article 32?
Okay, kindly see that there is no reason why he was not appointed. Ashma, kindly see, he's the 16 number. 17 to 23, they got appointed. And there were 20 vacancies. And they appointed only 18 persons. 2 vacancies were there. Then also he was not considered.
And Article 226.
Then I will withdraw and
withdraw. liberty to move the High Court under Article 226. 29.
Please, but in this matter, the main, my lords have already dealt with the cancellation of UGC net, my lords.
We have upheld it.
Only one. At page 17, I made a alternate prayer, my lords. What has happened now? The Haryana Public Service Commission has issued an advertisement on 2nd, my lords, inviting applications for assistant professor. The essential eligibility is net. Now net is rescheduled for 21st to 4th. I'm only seeking provisional. I may be permitted to be to provisionally apply.
You don't have a net qualification. Net qualification will apply. Those who don't have it will not apply. You don't have a net qualification. How can we allow you to provisionally apply?
What I'm saying is the net exam was cancelled not because of my fault. No. Now it is rescheduled from 21st to 4th. No.
The fact is you don't have a net qualification. How can we allow a person? There'll be other people in the country who will say that, look, why was this person allowed? We also didn't have a net qualification.
What I'm saying is, no, the exam is rescheduled not because
don't
of
have
me.
a net qualification.
If I only
That's
provisionally.
why the first prayer was a correct prayer. You wanted to challenge the cancellation of the exam. That we've
That
already
does
upped.
not survive, my lords. Page 17, my lords, may just see, my lords.
Not do that.
Only page 17, it's only
you.
a just prayer, my lords.
Not at all. Thank you.
Lords, after 5 years, those vacancies have arisen, lords. If I miss the chance.
You can't allow a person who does not have a net qualification to appear for the exam.
Subject to my, I will
That
not.
can't be. That subject can't be done in one case like this. Thank you.
Well, this is little departure from the other petitions, madam.
Yes.
This is regarding the petitioner is my lord 100% loss of vision. He had filed a petition, my lord, seeking a direction the government, my lord, having an integrated braille system, my lord, with respect to my lord, the medical prescription medicines like that, my lord, this currency notes and other things, because it is for them, they have to depend upon the others. And very, very difficult to find out what
do you mean by integration of braille system? What do you actually want?
Yes, my lord. In fact, my lord, it is very difficult to know what is the expiry date, what is the manufacturing date of a medicine they purchase, what is the quantity, what is the quality and all that, my lord. So they have to depend upon somebody else, my lord.
Notice here.
Please, Lord, can pray for some, my lord, some date, my lord, possible within
4 weeks.
4 weeks.
Liberty to serve the central agency.
Please, I'm so obliged.
Please,
yes.
Let's your lordship would see, as far as this arbitration award is concerned, it's a foreign award. Now, prior to the award had come, I had filed the suit. Meanwhile, the award came, I challenged the suit in the award. Challenged the award in the suit, and there is a finding with regard to the award in my favor, that there was no concluding contract between the parties. Now, there is no stay granted against that order. Meanwhile, in enforcement of that foreign award, the court has passed this order.
So the commercial court on 31st of January says that the award is null and void.
Null and void because there is no concluded contract between the parties. There was only negotiation which was going on. There was no concluded contract.
Then what happens?
Then now the foreign party moves an application for enforcement of the award under the provisions of the Arbitration Act now.
After it had been declared null.
Yes. And now this impugned order has been passed in that enforcement proceedings, asking me to pay and deposit and the other side to withdraw and take away.
So the first order was 15th of July.
Yes.
Where you don't appear despite multiple notices.
Yes, correct. I did not appear. Therefore, they passed that order. I moved an application for modification of that order. I said I'll deposit. I'll give a security. That security I've given minutes. But the court is now saying in the impugned order, the court has said that you deposit the money and the other side can take it away. When there is already a civil court decree in my favor. And that argument was specifically raised that the High Court doesn't deal with it. And that suit also is not ex parte, it is by party. It is contested by the other side.
what really does is this, para 7, if you just see the operative order.
Yes, Milord. It says, Milord, heard having considered the rival submission on perusal of the documents filed on record, as also the decision relied on by the counsel for the applicant, this court is of the considered opinion that looking to the various legal issues involved, which are rather peculiar, and the fact that the non-applicant has already filed its objection to the main application, the order passed by this court on 15th of July may be modified to the extent that subject to deposit of the principal amount of US dollars 1,53,000, which is about 1 crore 30 lakhs, some odd amount, on the basis of the exchange rate as exists today, within a period of 1 week from with the principal registrar.
That is, you have to deposit this amount.
That is correct. And further securing a removable property is worth rupees 3 crores. So, Milord, the award is of 1 crore 30. So, I have to deposit and also provide a further security of 3 crores.
For interest.
For 3 crores, Milord. That is what it is. Crores by filing an affidavit within a week's time. The direction in para 8 of the order dated 15 July that till the next date of hearing the non-applicant restrained from transferring the removable or movable properties in any manner is hereby modified and dispensed with accordingly. The amounts so deposited by the non-applicant may be allowed to be withdrawn by the applicant upon furnishing.
You are the non-applicant, right?
No, the other side. So they can, I will deposit it because this was my application. So I will deposit and they will withdraw it.
Amount so deposited by the non-applicant.
So I will deposit it.
May be allowed to be withdrawn by the applicant on their furnishing the solvent security to the satisfaction of the principal registrar.
But there is today, as far as this decree is concerned, now there is no decree passed because under 49 there has to be first a decree. Before that there has to be.
Today this is only an order allowing them to withdraw subject to solvent security.
Where is the question of them withdrawing that amount? I have given, as far as the award was awards of 1 crore 30 lakhs, I have given them further security of 3 crores. So that security is there.
Immovable property.
So that is correct. So that security is there.
Already deposited that $153,000.
I have not yet deposited this amount of money, but I have given the security of affidavit I have already filed. That I have done. So they are fully secured as far as that amount is concerned. Let the court consider and decide the matter. But why should the court allow them to withdraw the money and go away in the meanwhile?
It would normally mean a bank guarantee.
It is not bank guarantee.
For what? Solvent security?
A solvent security, suppose they give some property and UK I will have to.
That's never treated as solvent security.
So, question today is, as far as
they may not accept the security.
Today, there is a question of limitation also. There is a question of agreement with today. There is a decree in my favor.
It's a procedural order.
It's a biparty decree in my favor.
Where was the award rendered?
The award was rendered in 2017.
Where?
The award is stated 31/5/2017.
Where?
In US.
Did you challenge the award in the US?
No, I did not challenge. My suit was already pending here, and they have filed this execution after 7 years. So their award is in any case of.
Therefore, you have suffered the award against you.
I have
you file a suit here.
My suit was already pending before this award came. And
you never challenged the award in the jurisdiction which rendered it.
No.
You accepted, and you didn't. Did you participate in the arbitral proceeding?
No, I did not.
Okay.
But
now you've been asked to deposit. You deposit.
I have already given 3 crores. The award is.
Have you deposited the amount?
No. I have not yet deposited it. But what I have done is.
Will not interfere.
Let's kindly just see.
No, Mr. Jain.
Kindly just.
Client also has. You have to deposit and let them withdraw it subject to solvent security.
Solvent security is not bank guarantee,
Could be. In Mumbai, I know solvent security is usually treated as bank guarantee, not property. Not property.
At least I am secure, the money will come back. Otherwise, suppose I succeed,
the High Court will accept or reject the solvent security. That's the jurisdiction of the High Court.
The problem.
You have suffered an award. Why should we interfere at your place?
I have suffered an award. They have already suffered a decree against it. There is no stay against that order.
We have a commercial court saying that an international award is a nullity.
No,
just file a suit here and get some decree.
Here, that
you don't participate in the proceeding. You don't challenge the award in a proceeding before that court.
What happens is, your Lordship knows about it.
You are a party to the arbitration agreement.
But by
virtue of which jurisdiction was in the US.
That is the point, There is no arbitration agreement. That is the finding of the court. That there is only negotiation going on. There is no concluded contract. I can understand a situation where your lordship were to say, suppose your lordship were to say that the agreement has become void as a consequence of other factors. There is no concluded contract. And Millet, your lordship also knows because what happens in a foreign award also is that there are two stages to it. First is you decide on the question of enforcement. Second is an execution.
Yes, what enforcement?
But then Millets, the court has to first adjudicate on it. Today, Millets, in the meanwhile, the court is saying that meanwhile, we are not staying.
Yes, secured the amount in the arbitral process.
I can understand the matter if amount is deposited.
The Madhya Pradesh High Court does have the jurisdiction to secure the amount in the arbitration. You having suffered an award.
Plus, I have suffered an award, but they have also suffered a decree against which there is not the order. Plus, I can also understand
that decree is absolutely, that court had no jurisdiction to pass that decree.
Plus, I can satisfy your lordship that that the court had it, but I can satisfy it. But the point is like this.
What you had to do is that when he sues for enforcement,
yes,
then enforcement can be refused on the grounds which have been set out in 48 and 49.
Plus, let us for the time being ignore it. For the timing. Let us for the time being ignore it. Now, 49 at the stage of 44 to 49, there is still a decree to be passed after the court decides on enforcement. Two issues. First is an issue of enforcement, then is the execution. Therefore, a decree under 49 needs to be a decree of order of the court will have to be passed on that.
There is no decree. Today now, he has moved for enforcement.
Yes, the enforcement.
Has he filed for enforcement?
Yes.
He has filed for enforcement.
Yes, filed for enforcement.
You can raise challenges to the enforcement.
Yes.
Why the enforcement should be refused.
That is correct.
Court has passed an order in the meantime saying that secure the amount in arbitration.
Just securing an amount and securing an amount.
Whether he should be allowed to withdraw is within the discretion of that court. They have said solvent security. Why should the Supreme Court interfere?
Because
he has an award in his favor.
Plus, there is question is at this stage also, your lordship will also look at prima facie. What is the situation? Where is the prima facie situation where there is no concluded contract? There is already a finding to that effect.
That will be decided at that stage, not now.
Your lordship may at least say that as far as solvent security is concerned, let them furnish a bank guarantee to that effect. But at least I would be protected.
Solvent security, they have said to the satisfaction of the High Court. That judge examines that. They do not sit here and examine what is the kind of solvent security they will in future give. That's for the court to decide.
But the point is, as far as the award is concerned, the award is 1 crore 30 lakh.
Across the country, I know in Mumbai, the Prothonotary and Senior Master always looks at whether there is solvent security. They decide whether it is sufficient or otherwise. They can't just give any undertaking. So they might give a corporate guarantee. Then what is the value of that guarantee? Let that be decided by the High Court. Thanks.
Plus the amount
32,
is 1 crore 30.
32.
100.
Yes.
Milords, by the impugned order, Milords.
Question the High Court to decide it early.
That will not right. Yes.
Milords, by the impugned order, the Learned Single Judge, with respect, Milords, without issuing notice, Milords has virtually allowed the petition of respondent number 1, who is a third party to the arbitration agreement. Milords, there was an interim award passed by the learned arbitrator on 27th of February 24.
27th of February?
2024, Milords.
Yes.
And Milords, the respondent number 1, who's a third party, he files a 37 on 5th of April 24, which gets listed for the first time on 1st of August. And Milords, the Honorable High Court records that though service has been done but none has appeared, Milords, there is no proof of service. And from para 2 to 8, Milords, the Learned High Court records the submissions and passes the award.
Now, what is this is an interim order of the Learned Single Judge, right?
Please, Milords. And Milords, because of the interim, the impugned judgment, Milords, the court receiver of respondent number 1 is going to execute the award or the order and take the possession of property tomorrow at 10:30 a.m. Milords, that I have annexed at P16, page 245.
What was the section 17 order that the arbitrator passed?
Milords, the arbitrator, Milords, that's P13, page.
It's an interim order in terms of pre-clauses C and D.
Please, Milords.
Let us see what is pre-clauses C and D.
Milords, the prayer clause is at page 232. which is the arbitration petition filed by respondent number 1.
So the order of the arbitrator was appointing a receiver in respect of flat number so and so in that building.
That's been stayed by the High Court. And Major's prayer D.
And allowing and permitting R2 to 4 to occupy the flat as agents of the receiver. Who are you in the arbitral proceedings?
Major's, I am the claimant. I had lent money to respondent number 2 to 4. Major's, thereafter they were not paying, so an MOU was executed between us. They agreed, they acknowledged the liability. Thereafter, an arbitration agreement was executed. They failed to pay, so I invoked arbitration. And Major's, under that, I filed an application under section 17, which was considered by the arbitrator, and an interim award was passed. Now, Major's, the third party, respondent number 1, files a 37. And on the first date, the interim award of the arbitrator has been set aside virtually by the Honorable High Court. And Major's, without notice.
What is prayer clause? Is the matter made returnable by the High Court now?
Yes, Major's, it's on 29th.
29th of August. So you moved the High Court on the 29th.
My problem is, Major's.
Today's the 27th. You moved the High Court on the 29th.
Major's, may please have page 245.
Anyway, this order of the High Court was passed on 1st of August.
Yes,
Instead of coming here on the 27th, you should have moved the High Court for modification of the order.
Major's, may I record that this order, this execution, which is supposed to happen tomorrow, will not happen, and I'll move the High Court.
Look at it this way. When this impugned order is passed on the 1st,
Please, Major.
the only correct thing for you to have done was to move the High Court and tell the High Court, look, please hear me.
Major's, my problem.
You don't do that.
The problem which
You
we
come
had.
here on the last day and say, now stay the order of the High
Major's, the problem is there was no record of arbitration before the Honorable High Court, and the observations
You
made
move the
against
High Court. You move the High Court tomorrow.
Major's, we'll move that. Major's,
We'll not interfere at this stage, because if you wanted some stay by us, you should have come immediately. Why have you waited for the whole month?
Major's,
See, this is how a contrived urgency is created.
Major's,
You tell the court that tomorrow I'm losing possession, therefore now grant a stay.
Major's,
You should have done that before the High Court.
Major's, the order was made available on 5th. Major's, the order was made available on the 5th of August. I filed my petition.
First respondent is Punjab National Bank Housing.
Yes, Major's.
They have a mortgage in their favor. They have a first charge on the property.
Yes, Major's.
Therefore, the High Court has appointed a receiver.
Major's, may then just say that the execution, which is tomorrow, will be deferred. Major's, I'm not asking.
Not when you wait until the last day. These are just contrived urgencies. That's all.
Major's, then the observations which have come and.
If you want to withdraw this, you can withdraw it, move the High Court, point out to the High Court what interest you have in the property. We'll not make any observation.
Major's, but the High Court has prima facie said that the arbitration proceedings are collusive, they are sham. They've recorded that in the impugned order.
Maybe so, but you can then point out to the High Court why they are in error. It's an ad interim order of the single judge.
Major's, then
The arbitration took place between whom? Between you and?
Major's, respondent number 2 to 4.
And to the exclusion of Punjab National Bank.
Because I, as a claimant, I had lent money and I was supposed to repay it, and
that's the thing.
Major's, I paid money through banking channels.
It's purely collusive. Yes.
Major's, then let me withdraw the petition. Major's, with all my contentions kept open.
You can simply withdraw it. We don't mind you doing
Yes, Major's, I'll withdraw it.
Yes, sir. If not.
Grateful.
In this matter, my lord, High Court in a wrong presumption vacated my stay order, my lord. The aspirant number 7, my lord, who was participated in the bid proceedings, my lord, being an unsuccessful bidder, my lord, after being unsuccessful, he has challenged the tender conditions, and the first appellate authority has quashed the tender, my lord. On the very next day, the new tender has been floated by them, my lord. I have challenged the tender, the new tender, and the order of the first appellate tribunal, my lord, before the Honorable High Court, and subsequently division bench has granted stay order.
The FAA decided to issue a fresh tender, is it?
My lord, they have issued the very next day of the appellate order, they have issued the fresh tender, my lord.
What is the order of the first appellate authority?
My lord, may kindly see, that is that they have quashed the tenders, my lord, without giving me opportunity. I was not a party in that, my lord. I was not a party. I was the successful bidder. I was not making party, and they have quashed the first tender, my lord. And on the very next day, the second tender has been floated, my lord. I have challenged that order of first appellate authority as well as the tender, my lord. The High Court has stayed the tender, fresh tender, but subsequently, my lord, in a wrong presumption that I have not challenged the tender, my lord, they have vacated this stay. My lord, I have challenged the tender, my lord. That is all. That is in my prayer, in my grounds, everywhere is there. So, my lord, it is required to be interfered in this matter. Because
you filed a writ petition. Who filed a writ petition?
I filed the writ petition, my lord, because I was not a made party.
Now just read out this paragraph at page PDF page 30 if you want in page 2, irrespective of the merits of the case.
Page 2, my lord.
Yes.
Yes,
irrespective of the merits of the case, we find that when the first tender proceedings were set at naught and fresh tender was issued on 13th March, which was due fully within the notice and knowledge of the appellant.
Appellant filed his writ petition successfully thereto, did not choose to challenge the second. I have challenged the second tender, my lord. This is a wrong fact, my lord. I have placed the writ petition, my lord. May kindly see prayer of the prayer and the grounds, my lord. May kindly see page number 92, my lord.
Did you participate in the second tender?
My lord, I have not participated completely, my lord. May kindly see.
What do you mean not completely?
Not complete, my lord. May kindly see page number 125 of the stay vacant.
Did you participate in the fresh tender or not?
No, my lord. May kindly see 125 page number. There is a stay vacation application, my lord. There is stay vacation application, my lord. 125, my lord. May I read, my lord, with the permission of the honorable court, my lord? My lord, the BL Enterprises, which is me, the petitioner Suratgarh has submitted the tender has been floated on by the technical bids. The reason of not offering the tender, I have not deposited the money, my lord. That is, deposition of money is the basic requirement of participation in the tender.
The court has said that you participated in the second tender and your bid was rejected as technically not responsive.
My lord, participation means, my lord, I have to submit the money, my lord. I have not submitted the money, my lord.
But you submitted your bid?
My lord, only documents I have submitted, my lord. But my lord,
then out of
my lord, here.
You participated in the second tender.
No, not my lord, not.
The second tender was never challenged by you.
Yes, my lord, second tender has been challenged, my lord.
How can you, after you have participated in the second tender?
My lord, that was not a participation, my lord. I have challenged, my lord. May kindly see my writ petition and the prayer, my lord.
Participated. You say I didn't submit the money, but you submitted your bid.
My lord, documents were because, my lord,
what do you mean documents? You submitted your bid.
But my lord, it cannot make, my lord, the order of first appellate to be illegal, my lord, because without hearing.
Very simple principle of law. Once you submit your bid in pursuance of the second tender, that means you've accepted the retender. That's the end of the matter.
My lord,
got our point. Dismissed.
My lord, kindly, my lord.
Thank
my
you.
lord, please, my lord.
Got my point. I can't make you say the same thing over and over again. Yes.
Right.
Lord, this is the case.
Yes.
Where 2 coal mines were auctioned, Lord, by the government of India. One mine is called Mahan. One mine is called Baisi. Both required, my lord, bank guarantees.
Yes.
I asked the State Bank, my lord, to give me the bank guarantees in the format concerned. They gave both the guarantees. My lord, in both the guarantees, there were some typographical errors. For example, my lord, Baisi said Baisi, but Mahan had an error saying that not Mahan but Baisi. The second error was that the word 90 was misspelled, my lord, as NINTY instead of, my lord, the proper spelling of 90.
So you were declared technically qualified for Baisi but not for Mahan.
And now what is important is the same authority, my lord, which examined the bids, sent me a clarificatory letter for Baisi that these are small clerical errors. What do you have to say? Because the clause provides for clarification. I immediately asked the bank. The bank immediately issued an amended one and corrected it. I gave it and I succeeded in Baisi. In Mahan, my lord, no such letter came, but I realized it. The moment I got the letter for A, I realized it for B. The State Bank again gave an amended and I gave it well within time. On 29th, my lord, of February, the last date was 6th of March. But my bid there is rejected, though it was the highest by 600 crores. Why? Because, my lord, the value of the bid is 35,000 crores. You have to share the revenue with the government. Whoever shares most, my lord, gets the bid if you are qualified. I shared, my lord, I shared 8%. The successful party, my lord, has shared 6.5%. 1.5% of 35,000 crores is 600 crores. It's a mistake which has occurred by the bank. I realized it and I gave it. I showed you, Lordship, my lord, what the mistake was. Give a copy. My lord, just have a look at the actual mistake. that guarantee is not here, but I'll show it from here. Kindly, Mr. Court. Kindly see the mistake, my lord. In the one which is not approved, and then the one which is approved. My lord may turn straight, my lord,
What you are approved.
to page 25. This is, my lord, the Mahan guarantee given, my lord, by State Bank in favor of Government of India. Your lordship may straight away turn to page 31.
31.
31. My lord, your lordship will find the fourth line, Messrs. J.M.B. Road Lines Private Limited. Now the bank did not write the address. So this is one, my lord, error. But there is no two J.M.B.
This is from Mahan,
Mahan. I'm only showing you Mahan. Your lordship may note Mahan.
where you have been held to be qualified.
Yeah, by C I was qualified. Here I am rejected. But the point is identical in both. I'll show you.
Yes.
So, my lord, fourth line, one error pointed out by us was J.M.B. Road Lines Private Limited doesn't have an address. But there is no dispute about identity. Anyway, this is one. Your lordship finds 4 lines below J.M.B. Your lordship will find mine, then in capitals by C. My lords get that? 4 lines below J.M.B.
Yes, by C.
Kindly marked by C, it should have been Mahan. It is for Mahan. It should have been by C. But since by C was given, my lord, for bank guarantee, they made a mistake and added by C. So that is number 2.
But that means you never gave a guarantee for Mahan at all.
My lord, the bank gave a mistake of by C. I corrected it forthwith.
But you should have.
I'll show you, my lord, correction is allowed. If one was corrected, the second could have been corrected.
Mr. Ranjit Kumar, you are appearing for?
I am appearing for the successful.
Yeah. Now, see the third one, my lord, middle of the page. 13 crores 90 lakhs 74,468. See the spelling of 90? E is missing.
That's all right. That is a.
They said this also. Now, my lord, the last one, last line. However, our liability under the guarantee shall be restricted to an amount not exceeding insert amount. They didn't insert. Now, your lordship sees the guarantee of BIC.
No, next page also.
All right, next page also.
At the top.
Now see, my lord. See BIC, for example.
This guarantee shall be irrevocable and remain in force till.
Insert bank.
Insert bank guarantee expiry date. So it was not.
And next line also, and insert.
That's all right. That's all right, my lord. But see the earlier one for BIC.
But therefore, you didn't submit a proper guarantee.
See page 19. Now see page 19.
I can understand the spelling of 90 being wrong.
I'm not in 90. Page 19.
The bank gave a guarantee for a coalfield which was not the subject matter of that guarantee.
Correct, but it was.
It is Baisi when it should have been Mahan.
Correct, but it was corrected within time.
Yeah, the subject matter.
My lord, it is corrected within time. I'll show you the clause of correction. It's a mistake.
Then they pointed it out to you?
Yes, and bank corrected it.
Was when you corrected.
Yes, I'm showing you. That's what I'm showing, my lord. Now, for BIC, my lord, they corrected. First see BIC. Turn to page 19 of the same volume that I've given. 19. Your lordship will find page 19. This is BIC. Does my lord get it? So, fourth line, my lord, no address, same issue.
Yes.
My lord, BIC is BIC here. 4 lines below, no problem. So this is no problem. All 3 are otherwise same. See the figure 90. Again same. See at the foot below.
But most importantly, the value of the guarantee was provided over here. It says 192 crores 50.
Correct.
Crore 92.
Correct. Now, my lord, see the clarification asked for. BIC was corrected and the other one also was corrected. Now look at this, my lord. Your lordship may turn. See the correction, my lord. Turn to, my lord. Now turn to the main file, my lord.
So we take your word for it. For BIC, you corrected the mistake.
Because the authority asked me to correct. That is why, my lord, I corrected myself. At the same time, my lord, if you ask for one and don't ask for one, my ears perked up. I went to the bank the same day and got both. I gave both. And now I'll show you.
Just give us the dates. Which was the last date for submission?
6th of March.
No, my lord. 19th February, page 192.
6th of March.
Kindly see the page.
No, but there is a correction required. Correction
but
was done.
If that, what does the tender document say? Which is the last date for submission
Yes.
of bid? Then what is the last date for correction?
I'll give a lot.
192, my lord. Page 125. Page 125.
125.
PDF. PDF, sorry.
19-2.
Just one.
19-2.
PDF is 233, my lord. PDF is 233.
But that doesn't matter, my lord, because they asked for clarification.
Bid due date number 8.
Turn to 285 for a second.
Annexure.
285, my lord.
No, 233 PDF page is a schedule.
1 second. Just page 233.
PDF page.
That is general instruction to bidders.
Yes, see, no, my lord.
What clause would that be?
It clause number 3.8.1.
Already, we'll get that.
General instructions to bidders.
This is 2. Now, would your lordship turn, my lord, to page 285 PDF?
We have page 225.
Sorry, my lord. Schedule number 8 is the bid due date.
My lord, that makes no difference. They asked.
Let's see the bid due date, publication, pre-bid meeting, last date for
Number 8. Number 8.
bid due date.
19th February.
This was never extended.
No, my lord, this is what I'm trying to show you.
And the next one also, bid
No,
opening date.
My friend should allow me, my lord. Kindly turn to page 285 PDF.
Opening of tender of technical bids was 20th February 24.
20th February, next, my lord, the very next one.
After that, they asked me, my lord, is what I'm trying to
Date of examination of the technical bid.
turn to now. My lord, would your lordship turn to
So
PDF
start date was
285?
End
PDF
date-
285.
end date was 6th March.
Yes.
So just turn to PDF 285.
Now, what is the date on which you submitted your revised bid?
1st March was the date fixed at page 285. Just turn to 285 PDF. This is what I'm trying to show. PDF 285.
Internal page, internal page.
Internal will be 244, PDF 285, annexure P7. P7. So they asked me, my lord, to correct for by C. Would your lordship see that?
Yes,
See the date, my lord, 26/2.
yes.
So reference your bid for by C, please furnish the following. Now see, my lord, middle of the page, security. In the submitted guarantee at para 1, the registered address has not been mentioned, date of tender document not mentioned, name of coal mine has been incorrectly recorded as Ministry of Coal, Government of India Coal Mine by C, instead of only saying by C. And the amount is incorrectly mentioned because of the phrase 90. Therefore, last line, my lord, clarification required, etc., be furnished on or before 1600 hours on Friday, March 1, 24. So for by C, I submitted, my lord, what was required. The document is on record. And I succeeded in by C. When I got this, my ears perked up for the other one. I got that corrected also and I gave it. Now, my lord, the High Court says, well, you made a mistake. High Court is oblivious of the fact that the mistake occurred in both and one was corrected. And I want to now show you, my lord, that there is a clause for clarification. It can be done. It's not as...
Clause?
Yes. Your lordship will find, my lord, that clause is 204 and PDF should be 245, clause 5.11. Kindly turn, my lord, to 204 or 245 PDF 5.11. The clause is clear as daylight. And same clause is in both, same authority in both, identical bids in both, Government of India in both. Just because in one it is asked, one it is not asked, how can there be a difference? See 5.11, my lord. Modification, substitution, withdrawal. The bidder may modify, substitute or withdraw bid after submission provided that written notice is received by the authority prior to the bid date, which is normal, that it should have been before 19.2. In accordance with the process, no bid, etc. will be entertained. Now, but when you ask for it yourself on 26.2, which is, my lord, 1 week after 19.2, and the last, my lord, date, they said you do it by 1/3. And then 5.11.2, my lord, you also see that also.
But Mr. Rodgi, it says no technical bid shall be modified after the bid due date.
But
Now-
they asked me.
Now, one second. The bid due date
Was 19.2. But they asked me on 26.
For something else.
For the accompanying tender.
For Maha.
For
But
YC.
For YC.
But not with great.
But if they
What
did
is-
it erroneously, can we say that it creates a vested right over here?
No, not.
Could you have modified your bid after 19th of February?
But my lord,
You got the benefit in that other coal field, God knows why you got the benefit. But can we say that you have a vested right?
see the next clause for a second. See the next clause for a second. 5.11.2. Any alteration or modification information supplied subsequent to the bid date, unless the same is expressly sought will be disregarded. So, my lord, with strict letter of the law, they say you gave it yourself, we'll disregard. But when we ask, we won't disregard. But, my
No,
lord,
but the point is that, once your bid was.
I understand.
You give a bank guarantee, you give a guarantee in respect of a coal field, which is not the subject matter of that tender.
My lord, was it my mistake, my lord? The bank.
It was.
The bank gave it.
I know,
asked
but
the bank.
I know, but the bank gives it to you. It's your agent. State Bank of India is your agent.
No, my lord, with great respect, my lord.
The bank you have to blame, and State Bank of India is acting as your agent.
But what about, my lord, what about the fact that I'm 600 crores better?
55 years.
The bank also wrote a letter saying that we made a mistake. My lord, with great respect, this is, my lord, this is penalizing somebody. It's the penalizing somebody, my lord, at the extent of the exchequer.
These are all experienced bidders. You knew that, you had to give a bank guarantee in respect of a coal field, which is not the subject matter of that tender. You mentioned the wrong coal field.
Lord, I can only tell Lordship.
You have to sue State Bank of India that, look, I lost this contract because of you.
Next page, my lord, 5.12.3, Lordship may see, kindly
There is a recent
5.12.3,
case.
number E.
Without bid security.
Without bid security or period of validity. The period of validity was not there.
There is a recent case of a mistake where this court allowed me to correct at some cost which was imposed. Your Lordship may have a
Not when a third party rights have been claimed.
This
Thank
was
you,
a second
When a
auction
third
for
party
the same
right-
mine.
600 crores more. Lord. Why should it be?
45 years.
50 years, my lord.
Yes. Item 35,
Very obliged. Wait.
will re-notify it. Next week will be.
Now in item 35.
Can we just re-notify it because it'll take a little time?
Oh, all right. It's an admission, otherwise it's a fresh matter.
We'll just pick it up next Monday.
36 or
Well, it's week after that. no?
Well, I've circulated,
No difficulty. Take it after 2
Yes, week
I've
after.
circulated a written note for 36, my lord. Lordship wants to take it up some other day. I've given the notes in that.
We've seen that on the withdrawal of the exemption.
Yes, there are 2 points. But can you take, as a withdrawal expenditure can be of income?
All right.
That's the one. I told
We'll
Mr.
just look at your note. We haven't seen the note. We'll just make sure that it's
They're basically
सबको circulate करो soft copy में.
And what I also given accounts, I received subsidies of 232 crores, of which 82 crores has gone as tax.
All right. We'll look at your note and maybe next week we'll take it.
Respond to that, my lord. We are ready in the matter. Whenever it's heard, we'll.
Okay, no difficulty. 23rd September. then.
23rd.
I told Mr. Venkatraman.
Yeah, I'm here, my lord. I'm here.
38.
Where are we getting up? 37 has already been adjourned.
37.
Already adjourned.
The OBC matter, no? It was tagged in the morning and we have posted it with the other group.
Mr. Sibbal mentioned.
Mr. Sibbal mentioned.
Please. Apply.
38, my lords, is
Your lordship.
Your lordship, see your last order.
We'll be tempted to mention or argue, my lord, till your lordship rises.
Diwan, can we post the rest of the board?
Yes, because this is that one where you had
We
requested.
had asked for that clarification
That's come now.
from the.
That's come.
That's come now.
Yeah. You may keep it on whatever. If you want Friday.
Friday we'll take.
Friday. This Friday, Manoj. This.
So between now the after notice matter This Friday or next, you can distribute the matter.
There is.
No, sorry,
Unless-
this Friday or your lordship said?
You would like
Monday.
Or next Monday.
Yes, I don't mind either way.
Next Monday we'll take it.
With your lordship's permission, my lord, sir.
That journalist matter, glorification. Your lordship is twice going short dates. Journalist matter,
My lord, that is 42.
Friday or Monday.
42. Where we have protected 16 FIRs.
No.
Not that much.
This is that case of ABP channel.
For the AP we've done.
This is a very
Yes,
different case, man. Friday.
Royalty on royalty.
So 42,
Monday.
42 we take up on Friday.
54, 53.
42 Friday, 44 on Monday.
Lord, 53 on Friday, my lord. 53 on Friday.
The country adoption matter 15 months.
When do you like your matter, Mr.
Any day, my lord, as early as possible.
Denotify.
Because-
Malotra's matter denotify after 2 weeks.
My lord's item 4,
My
my
lord,
lord's item 4, the Ames matter which was passed over.
Friday we.
Friday.
My lord,
There's only one.
the Manipur students matter is item 5.
Friday we take.
Much of that.
Those were requested 46 to be on
We
this.
take that on Friday. It's a fresh matter, so it will come up high on board.
4 is Friday.
Friday. My lord has put
40. But item
Friday.
But items 40 is also a
You wanted Friday week? Yes. All right.
Well, 53 is already on Friday.
No,
53
4 is Friday, my lord. Your lordship is having 4 on Friday, that Ames matter.
Yes.
Very well.
Item 40 is a freshly adjourned matter, my lord. It hasn't come up.
And that will be take up on Friday because it will be high on board.
On Tuesday, my lord. Not on Friday, but on
All right, we'll take it up on.
Those were requesting.
Monday is over.
long weekend.
Those 46 may be retained on this Friday. 46.
46.
Grateful.
My lord, please, my lord, item. Requesting 2 weeks to file counter.
All right, 49, 2 weeks to file.
My lord, item 54, my lord, the settlement has been reached.
49 में कोई interim order होगा?
Please.
Please.
Lordship,
may I mention item
61.
Direct him to list it.
Friday.
Friday week.
Your lordship, item 61, your lordship, it is a matter related to admission in medical college, your lordship. Last date is 4th September for.
Friday we'll take it up.
My lord, item 50.
Notice matter or?
It is a fresh matter, your lordship.
Lord,
I
item
have it tomorrow, your lordship, since the last date for physical document verification is 4th September.
Keep it on Friday. No.
My lord, 58 is a case matter, my lord. It's a tender matter, my lord. Maybe on Friday, my lord.
Which one?
Item 58, my lord. Item 58.
All right, Friday.
On item 54, lordship, settlement has been reached. My lord had asked for the verification to be carried out.
Arbitration petition, Lord.
They want one time to file a counter? Is it after notice?
Yes, my lord.
All right, we'll give you time for filing.
It's 47, which Ms. Mona mentioned. my lord.
Connected to 42, your lord.
Which one?
The ABP.
Yeah, we've got,
60 and
we've already
63 are
passed that order in the morning. All the ABP matters have been grouped together.
My lord, item
Sorry,
54,
but
my
40
lord, settlement has been reached. Your lordships are directed for the verification to be carried out. So it's,
Same, yeah, he's already done that. Both
Lord,
matters are together.
I'm sorry to mention it, the end was 47, which Ms. Mona mentioned.
Yes.
My lords, can it be a little longer, my lords, 2 weeks? Because I have some logistical challenges, my lords. The respondents are in Italy, my lord.
Honest? He wants a little longer than 2 weeks.
Yeah, because apparently the
additional-
Italians take the
give an
holidays very
additional-
seriously, my lords. I'm not able to get
An arbitration matter will.
it. Arbitration.
Additional week.
An additional week, my lords. In that week of 15 September.
All right.
if it's-
Item 39, we're supposed to file an affidavit, we filed it,